1 second. I'm just counting how many from 6, 7 to 17, 8. 3 yards है अपना 400.
This is withdrawal case of ESI case under amnesty scheme.
Amnesty withdrawal का होगा ना order होगा.
Minor.
Withdrawal memo file करचंदी.
नहीं मेमो देछि काली आसिले withdrawal करी.
नहीं सीधा कौन withdrawal लिखचंदी.
ना लिस्टिंग ପାଇଁ
legal proposition टा बुझुचंदी.
आज्ञा.
Just for it point. See. अपन फ्रेश ना
ना नोटिस जाइतला से माने जवाब भी देछि.
जवाब दीचन. हां. ठीक कॉपी डाटी सॉल्व करन तांकू. स्टैंडिंग काउंसिल
कहि दउछि तमको. तांकर से ESI काउंसिल आसन.
हमर मने रहबन. यू आर ए बिजी काउंसिल आपनकर मने.
नहीं सॉरी. मु कहि दे
कॉपी डा देथिले भलो ही थाना. से तो फाइल काढी के आनी. ऑर्डर से केबे आनी परिबे? सो बारीक.
वी काउंसिल 6
वी कमेंसिंग 6 से. ठीक है मैडम. ऐसा ऑफिस तरीके है ना ठीक है.
2 यार. अरे 2 यारी हबनी.
तुई माने काल परदिन काली.
हां.
तो सेमती करूनी. स्पेसिफिक डेट न करी सो दैट आई एम एडजस्टिंग एवरी बिकॉज़ आई एम अलोइंग ऑल
माइनर.
हैला. अब वो मेमो को मिस्टेक रखिया पड़तला.
मिलर्ड
रखले फिर अनुमान खराब है बिन.
मिलर्ड
मेमो दो चली जा.
Milord, memo already been submitted online. Milord, already I'm in virtual.
आउथरे दियंतु.
Several times already been submitted, your lordship.
अजे मु तो मेमोटा हैंडल करूनी आपण को जोठी दउचंती आपण कोन ऑनलाइन कोठी देले.
बालेश्वर
ऑनलाइन बालेश्वर मेमो केमती आछी.
डीआरएम बाबू आछी
मेंशन मेमो.
हां. तो हम काढी करे.
मेंशन मेमो एठी काढी परिबनी से. जेला डीआर का पक्ष आछी कारण एक्चुअली अपने कोर्ट इज नॉट ओपन टू फाइलिंग ऑफ दैट ये. आपण गोटे काम करंतु नंबर टा कोंतु.
WPC 8139 of 2025.
8139 of 2025. Fresh admission orders after notice कौन आ गया?
After notice, I already been submitted on 26th August.
After notice matter रे सीएन एठी कोर्ट रे से 400 मैटर लिस्ट करचंती आपनकर टोटल अप टू 3-8 है. केमिति सेडा यू हैव टू बी पेशेंट. फ्रेश मैटर दिया छै फर्स्ट प्रायोरिटी देन ऑर्डर्स अपीयर करचंती अदर साइड.
Milord, I am from the opposite party. I'm for the opposite party.
Why you want mentioning listing of the matter?
Because this matter is a family matter. Already been filed. This EP has been filed in at Bhubaneswar Family Court number 2, Bhubaneswar. Transferred from Balashwar. Transferred from Balashwar. This to
कौन इट इज सब मैटर फैमिली मैटर अपन कौन कहउछन फैमिली मैटर.
the matter already order has been passed, but the petitioner has
अरे यू आर नॉट आर्ग्यूइंग ऑन मेरिट्स. गोटे लाइन कहबा को प्रैक्टिस करंतु. गोटे वर्ड कहबे व्हाट इज द अर्जेंसी. गोटे वर्ड अपन जदी अर्जेंसी कहबे नेबे ताले केमती हबो. सब जगह फैमिली मैटर तो एठी
already
अन्य मैटर भी अछि. आपण भले बहुत मैटर अछि. आपण कोन कहउछन मु बुझी पने. व्हाट इज द अर्जेंसी इन लिस्टिंग. आई एम आस्किंग यू.
urgency
कौन
matter to be hard that to be
cannot be you no lawyer no case cannot be prioritized. It has to be in seriatim. It has to be serially.
Milord.
If any other matter is not pending, obviously every day I am hearing what is the difficulty. Even there is no specific date that I am not hearing any matter. 25 मजे मैटर केमती मु आगो नै आसीबी. से तळको ही जीवो कंप्यूटर रे. आपण हाई कोर्ट प्रैक्टिस विषय टिके बुझियो चेष्टा करंतु. कोन करा जाई परियो कोन होबो टे बुझंतु.
Your lordship only it is
lordship is nothing. No prioritize. आपण मते माय लॉर्ड कहउछन बोली मु कोन जाने ता करबी ना कोन. सेमती नो. कोन चाहुचंती तो कहि पर ना. आपण जदी चाहुचंती कोन देन यू हैव टू टेल दैट टू द कोर्ट, नॉट दैट लॉर्डशिप ओनली.
but this
से केस नंबर लेखंतु. बालेश्वर जदी आसी नथिबो आपण काली आउतरे आसंतु मेंशनिंग आवर रे सही देखिबा कोन. काल देखते काली पर दिन ना कोदन कल सकाळे हबो. आज देख परी नले पर दिन को देखिबा. पर दिन को से देखिबे कोन हेछि.
to vacate this stay only. That is our prayer.
समय लागिला कितने समय लागुचे आपन सेटा कहबा पई after you made a speech I gave a curt answer you are the straightforward answer then you सेटा कहबे vacation of stay पे कोन करछंती what
Already-
steps you have taken
I already been submitted.
आय नंबर केते देखो भाई
I 106 of 2025. I number
202 ता सांगरे अछि एटा WPC कहले
WPC 8139 of 2025 and IN number
कोनटा चैलेंज अछि
challenge is the order passed by the
प्रोविजन कहबे ना को प्रोविजन ने कोन ऑर्डर चैलेंज अछि ठीक है छाड़ आप समझ नेक्स्ट पेज तक all memos are allowed yes
Vehicle list, page 1, 1 to 9.
कौन सर
This is background to seeking vehicle with the liberty to find a place.
liberty cannot be granted sir liberty cannot be granted dismissal amounts to a right accrues to the other side
Cannot establish any contact with the patient status.
which provision in the CPC is there when contact is not established the matter has to be withdrawn have you read the wakalatnama once you accept a brief not pursuing is amounts to misconduct on part of the lawyer but if you do not establish contact at what stage you can say that the petitioner is not cooperating only for trial in a revision application nothing remains have you not accepted wakalatnama have you not received the fees so this you have to be careful we are being watched both of us entire fraternity is watched I have come from that side but what you are saying is correct so what you need to do you know you should not withdraw this you have to send letters with registered letter you will receive it you will not respond that memo along with the letter memo everything you file in court otherwise it is a serious affair once because the responsibility is yours RPFM रे कोन आपण कांटेक्ट कले कोन कर परिबे ना वकील फाइल करिवे फॉर वेजिटेशन एंड कांटेक्ट राइट please be serious whatever you say never make anything out of context no loose statements your greatest asset is your words it has to be measured nuanced what you speak what you understand I am not criticizing it can't be a critique I don't believe in criticizing or finding fault first of all but it is your choice it has to be dismissed stay has been granted have you read the last order that's a tragic event the lawyer not reading the order is a tragic thing for a case पढ़ंतु that has been upon DICT sir just touch कर दियो ये नहीं की बुक पार्ट नहीं बुक मार्क बंद क्यों बुक मार्क खोलो पढ़ो सर can you read
The matter was presented with this court on 17 March 2023 and thereafter it is displayed today after 3 years and 2 months for fresh action. Learned counsel for the petitioner seeks adjournment at the beginning of the day's proceeding. Accordingly, to grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing 29th of June.
if you read this then your prayer is completely not in sync with this observation it is not that you come it is a fun I mean it's a process is you file a application it is listed after 3 years then to get an opportunity it is listed then you say that let it be withdrawn with liberty to file again that's not in sync with this and that's of course not legal also it can't be जी जेतोळे असले फाइल कले तापर the entire blame goes on the judiciary that matters are kept pending What is this? Why you have kept the matter pending for 3 years? What prompted you? You have to be fair to the system also. So, upon senior sir, kotha hai na kon? Talk to your senior.
May please.
The matter, it is submitted upon na kon sir?
SM Adarsh.
SM Adarsh Das. SM is for Subhranshu or what?
Smriti Mahima Adarsh.
Smriti Mahima. Mr. Smriti Mahima Adarsh Das at item 2 level. Smriti Mahima Adarsh Das on behalf of Democracy Party for the petitioner. After the matter was listed after 3 years of presentation, the following order was passed on 22/5/2026. You take your seat. Sorry, actually I have interrupted your item 1 and because he mentioned, so you take your seat. Only. Who? Which? Following order was quote kar dena, hai na? Today, when the matter is being listed for fresh admission, is mentioned by the Lord Counsel for the petitioner, stating that the petitioner wants to withdraw the matter with liberty to file it again. Stop. He is apprised of the position in law that after filing of the division application, it can't be withdrawn. After 3 years, with liberty to file it again. Stop. It is further submitted by the Lord Counsel for the petitioner that the petitioner, despite efforts of the Lord Counsel, remains incommunicado. Stop. To grant further opportunity, the matter shall be listed for fresh admission. The week commencing 6/7. ଆପଣଙ୍କର ମ୍ୟାଡାମ କୋଉଟା?
Item 3, my lord. I am praying for an adjournment, my lord.
ବୋଥ୍ ସାଇଡ୍ ଏଇଟା ତ ଆପଣଙ୍କର ଆପଣ ବି ରାଜି ଅଛନ୍ତି?
Last 3 years.
Dismissed.
I'll take instruction, my lord. I'll take out next week, my lord. I need it.
Last one. They are most kind.
You see, the other side may be hapless. The court is
Yes.
not hapless. ଦେବେ ନା dismiss ହବ?
Then
କୋଉଦିନ
my
ଦେବେ?
lord, I will take instruction, my lord.
Instruction
Written
ଦିଅନ୍ତୁ।
that, my lord.
ତାହେଲେ instruction ଯଦି ନେବେ ତାହେଲେ dismiss ହବ।
Can
ତାହେଲେ
this matter
first
taken-
second matter ରେ କାଇଁ adjournment
My
ଦଉଛୁ?
lord, can this matter take out day after tomorrow, my lord? I'll take instruction.
ପଇସା ଦିଅନ୍ତୁ।
Yes, my lord.
ଏଠି bargain ନୁହଁ. It is not a market. Must understand.
Yes, my lord.
You are not holding a ଜିନିଷ ଚିଠା ନୁହଁ। CPC ଧରିଛନ୍ତି। CPC ରେ କୋଉ provision ଅଛି ଯେ adjournment ଦେଇ ହବନି ବୋଲି? କୋଉ provision ଦେଖିଛନ୍ତି? କୋଉଥିରେ ଡିକ୍ରି ଚ୍ୟାଲେଞ୍ଜ ହୁଏ? ଦେଖିବେ। You have spent sufficient time, madam. I've been watching. The last 30 years I've been watching also. You have spent sufficient time. ଆପଣଙ୍କୁ ଯେତେବେଳେ ସିନିୟର ଆପଣଙ୍କୁ ଗୋଟେ purposefully ପଠଉଛନ୍ତି to make a illegal submission or a wrong submission, avoid that. This I have done. I have never sought for adjournment from the day one. When I started 30 years back, I have never sought for adjournment. I was rather, others were annoyed, seniors were annoyed that he is not taking adjournment. Not done. ଆପଣଙ୍କ ନାଁ ମ୍ୟାଡାମ?
Mohini Sahu.
Sorry,
Mohini Sahu. M Sahu.
Miss Mohini Sahu ଅଛି power ଅଛି on behalf of the petitioner. The matter is mentioned by the Lord and Proxy Counsel on behalf of the Lord and Counsel for the petitioner at the beginning of the day's proceeding. Being listed for the matter being listed for fresh admission. Mentioned that the last. ये बाहर की देखिए साउंड होची कोर्ट रे किछ आर्गुमेंट नहीं बाहर की बहुत आर्गुमेंट The argumentative Indian boy padya katha actually by Amartya sir. Last time. Adjournment is sought for. Stop. The Lord counsel for the opposite party opposes the prayer for appearance at Dakini. Mr. Expert Naik.
Last one.
Mr. Emma Sam. Oh, that is how they have sent Ms. M. Sam. Okay. Mr. Emma Sahoo for the opposite party. Right. Adjournment stating that though the matter is kept pending after issuance of notice, the petitioner is not paying the judgment, the maintenance directed by judgment dated 7/1/2025. Stop. The revision arises by filing the revision, the petitioner husband in the marriage challenges the judgment dated so and so 7/1/2025. তারপরে 12টা সেটা সাউন্ড ক্যাপচার করছে ক্লোজ এটা তো সেটা ଗୋଟେ প্রবলেম এটা আম্পলিফাই ହେଇକି বডি যাଉଛି তো ରାୟଗୁରୁ ଆପଣ ଫିଜିକ୍ସ ଥିଲା ୟୁ ଆର୍ ନଟ୍ ସାଇନ୍ସ ଷ୍ଟୁଡେଣ୍ଟ ଆପଣ ସାଇନ୍ସ ଷ୍ଟୁଡେଣ୍ଟ ନୁହଁ ନା ଆପଣ yes passed by the learned judge family court Jharsuguda in CMC number 20 of 2023. The CMC अरे फोन दे डायरेक्ट हम सुनते हो जो हेलो पूछो कि जा सर कहि दो जा सर कथा हो जे फोन रे कथा हो ना डायरेक्ट रूम रे कथा अरे आपण जानतु नि आज्ञा आपण को कोन कहबी बोली आपण बसतु आई जस्ट पिक अप समथिंग टू मेक इट लाइटर आपण को कुआडे गले सीनियर जूनियर कुआडे गले से भी फोन करथिबे कहबे सर पचारथिले जज पचारथिले जो हेलो कहउछन तापर किछि कोहंतु कोन कहउछन कोन चाहउछन कोन सो दैट मु रिप्लाई दे पारि इफ एनीथिंग नॉट सीरियस ताले कोर्ट करे कोन कोन yeah the CMC was filed by the wife in the marriage and the minor child born from the wedlock nahi bahut wife in the marriage seeking maintenance under 126 under section 125 of CRPC into bracket since repealed and substituted by section 144 of the Bharatiya Nagarika Suraksha Samhita bracket closed minor child okay इतना कोन आपण माइनर चाइल्ड को पार्टी करना थी सी भी पार्टी न अच्छा ट्रायल कोर्ट से पार्टी करना लिखी चंदी फॉर माइनर चाइल्ड maintenance amount sought for was rupees 30,000 per month. However, the learned family court granted the bahar important कथाबार्ता जाउची बुझियो होई बुझो at the rate of rupees 5,000 for the mother and child. Upon instruction, it is submitted by the learned counsel for the petitioner that the petitioner remains in default. किछि पैसा दो ना नहीं कि default in paying the amount due from 01.08.2023 that is date of application made before the family court. Stop. The learned counsel for the petitioner is apprised of the provisions contained in CPC. Order 41. The provisions and the principles. The provisions of the CPC and the principles contained therein. Order 41. माने XLI करि परिबे then rule are 1 dot into bracket English 3 comma, rule 10, R10, R11. The Lord Council is also apprised of the judgment rendered by the Honorable Apex Court in Samim Rajnesh versus Neha, wherein it has been held that the amount directed to be paid as monthly maintenance under section 125 of CRPC is akin to a money decree. Comma, stop to comma, for which to seek revision, the petitioner has to secure the amount before this court or deposit the amount before the learned family court. Stop. The learned counsel for the petitioner is also apprised of the scope of interference by this court in exercise of revisional power in orders passed by the learned family court, in judgment and order passed by the learned family court, directing payment of maintenance under section 125 of CRPC. Paragraph 3. Purnima Faruqi, exercise 2021. Paragraph. The petitioner, in order to sustain the revision, shall file affidavit giving the details of payments made, if any, indicating the date, mode of payment, and amount paid. Stop. If not paid, the petitioner shall also indicate in the affidavit how he will secure the amount in order to sustain the challenge. The affidavit shall be filed by ସେପଟୁ ରଖନ୍ତୁ ଏଇ କନଫ୍ୟୁଜନଟା ଆପଣଙ୍କର କେମିତି ଆପଣ ତ ସିଆଡୁ ବନଉଛନ୍ତି ଆପଣ ତ ବୁଲୁଛନ୍ତି ସେତେବେଳେ ସେଟା ଆପଣଙ୍କୁ ଓଲଟା ଲାଗୁଛି affidavit shall be filed by 10/7 yes Sahoo
Yes.
10/7 10/7/2026 the matter shall be listed upon serving copy thereof on the learned counsel for the opposite party the matter shall be listed ठीक है 15 जाए फाइल करो से साहू 15 फाइल से तो दउनांती एमती रे किछि आपण एग्जीक्यूशन
We have also filed an interim application to stay of the initial.
एमडब्ल्यू এটা পঠাই দেওয়া আছে তাহলে affidavit shall be filed by the 10/7 the matter shall be listed in the week commencing 13/7 copy of this order shall be forwarded to the learned judge family court Jharsuguda to be kept in the records of so and so उस पर लिख CPC या CMC जाती है if you do not state the law before the client will never listen you. You must understand you are in an exalted position. Yes, next.
Item 12, I want to withdraw, my lord. Petitioner doesn't want to proceed the matter.
एमती जदि हमें सब आरंभରୁ ଦେଖନ୍ତୁ ଆମେ ଅଧଘଣ୍ଟେ ଖର୍ଚ୍ଚ କଲେଣି ଖାଲି ମେନସନିଂ ରେ
ଟିକେ ଛୋଟ ଏଟାରେ କିଛି ନାହିଁ
ନାଇଁ ଛୋଟ
No
କଥା ନାହିଁ
no notice was issued.
ଆପଣ ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ ନହେଲେ ଆପଣ
Fresh.
କୁହନ୍ତୁ
Fresh
ଆପଣ
admission.
ଏଇଟା ଡାକିଲେ
Fresh admission, no notice was
yeah,
issued.
fresh or stale is not important. We have to follow some pattern. So, if I have completed the orders. Dictating the orders takes time also. I mean, exactly half an hour we have spent in mentioning. That's one କଥା. ଦିଅନ୍ତୁ କାହାକୁ ଆପଣ କାହାକୁ ଇଣ୍ଟରେଷ୍ଟ କରି ଦିଅନ୍ତୁ ଆମେ ଦେଖିବା ଆପଣ ମେମୋଟା ୱିଡ୍ରଲ୍ ମେମୋଟା ଲେଖିଛନ୍ତି
Withdrawal, ma'am.
ଠିକ ଅଛି but it can't be a simple withdrawal like the as I have mentioned in the Mr. Tripaঠি's matter. So Atmajit was
Here, my lord,
whatever. Again, we are spending time. Item 1 kar.
Item 1,
35 minutes. 35 minutes. 6 for adjournment.
ଆପଣ page ଗୁଡାକ ଡାକି ନେବେ. I'm so sorry. Yes. ବହୁତ ସମୟ ହେଇଗଲା ତ.
page 2, 10 to 22.
Item 10, my lord. Happy for adjournment next week, any day.
ଆଜ୍ଞା
My item 10, my lord, I prefer an adjournment. I am not Sambhalpur, I am suffering.
10 টা ডেট করে দিন।
Next week, any day, my lord.
27/7
স্যার উই কমেন্সিং 27/7
Overlay, my lord. Overlay.
ଆପଣ ସେଦିନ ସମ୍ବଲପୁର ନା କଟକ ସେଟା ଫେର
Sir, Sambhalpur, sir, 38 items. That also I prefer adjournment. Item
Next
30.
week.
Item 8, my lord.
8
Item 8 next week, my lord.
8 ଆପଣ କଣ ଆପଣ ନା ବଦଳେଇ ଦେଲେ ଆପଣ ତ ଛାଟୁ ହିଁ ନୁହନ୍ତି 8
Really?
ହଁ ତ ସେ ଆପଣ ଦି ଜଣ ଯାକ ଅଛନ୍ତି ସେ କଣ ଛାଟୁଙ୍କ ପାଇଁ ମେନସନ କଲେନି ଆପଣ କଣ ଆପଣ ଶତପତି ହେଇଗଲେ
My lord, sorry, I'm 7, my lord. Pardon, my lord.
ସଡ଼ଙ୍ଗୀ
My lord, my lord.
ଠିକ ଅଛି
Next week or after week? This case is filed 6 months back. But the status of the case ମୁଁ କଣ ଜାଣିନି next week or after week ଆସିଲେ ମୁଁ ଇନଫର୍ମେସନ ନେଇକି କରିବି।
ପ୍ରଥମ ଦିନ ଏମିତି କଥାବାର୍ତ୍ତା କରିବେ କ୍ଲାଏଣ୍ଟଙ୍କ ସାଙ୍ଗରେ ସବୁ ଇନଫର୍ମେସନ ଆପଣଙ୍କୁ ଦେବେ ଆପଣ ତ ଡରୁଛନ୍ତି ଆଉ
ନାଇଁ ଡରୁନି ନନ୍ ଓଡ଼ିଆ କ୍ଲାଏଣ୍ଟ ତାଙ୍କୁ ଡରିବି
ଆଜ୍ଞା
ନନ୍ ଓଡ଼ିଆ କ୍ଲାଏଣ୍ଟ ଡରିବି
ନନ୍ ଓଡ଼ିଆକୁ ଟ୍ରାନ୍ସଫର କରିଦେବେ ମିଷ୍ଟର
My lord, item 11.
ଆମର କୋଉ ଲାଙ୍ଗୁଏଜ କହୁଛନ୍ତି
ସେ ହିନ୍ଦୀ
ଆପଣ ବି ବୁଝୁନାହାନ୍ତି ସେ କୋଉ ଲାଙ୍ଗୁଏଜ କହୁଛନ୍ତି ସେ ଆହୁରି ଭଲ one matter was argued for 2-3 days on the ground that I am seeking amendment because the earlier council could not follow Hindi
ହିନ୍ଦୀ ଆମେ କହିବୁ
এই কোর্টরে চালিলা সেটা মানে পুরা amendment
My lord, item 11.
তার টিকে রুন 7 টাকু রখন্তু ଗୋଟେ ডেট করো
मुख्यमंत्री 20 sir.
27 27 ଆପଣ ହିନ୍ଦୀ ଜାଣିଥିବେ
ହିନ୍ଦୀ
କାଲିଠୁ ହିନ୍ଦୀ ପଢିବ ନା କଣ
ମୁଁ ହିନ୍ଦୀ ଜାଣିଛି
ତାହେଲେ କାହିଁ ପ୍ରଥମ ଥର କାହିଁ ବୁଝୁନାହାନ୍ତି ନନ୍ ଓଡ଼ିଆ କ୍ଲାଏଣ୍ଟ ଯୋଉ କହୁଛନ୍ତି
ନନ୍ ଓଡ଼ିଆ କ୍ଲାଏଣ୍ଟ ଆପଣ କହିଲେ ଡରିବେ ତ ମୁଁ କହିଲି ଡରିବି କେମିତି ଉକିଲ ଦେଇଛନ୍ତି
ଆରେ ଆପଣ ତ କହୁଛନ୍ତି ଆପଣ ବଢିଆ ମୁଁ କହିଛି ଏଇଟା ଆପଣଙ୍କୁ ନା ଆଇ ରେସ୍ପଣ୍ଡେଡ
ମୁଁ ପିଟିସନ
ଆପଣ କଣ କହିଲେ ମୁଁ ସେଟା ଯୋଉ କହିଲି
ତାହେଲେ ହିନ୍ଦୀ ବୁଝିପାରୁଛନ୍ତି
ଆପଣ କହିଲେ ଇନଷ୍ଟ୍ରକ୍ସନ ମୁଁ କିଛି ନାହିଁ କଣ କେସ୍ ଷ୍ଟାଟସ ଜାଣିନି 6 ମାସ ହେଇଗଲାଣି
ଆଜ୍ଞା
ତାର ମୁଁ ରେସ୍ପଣ୍ଡ କଲି ଯେ ଆପଣ ପ୍ରଥମ ଥର ଏମିତି କଥାବାର୍ତ୍ତା କରିବେ ଯେ ଯେମିତି କି ସେ ସବୁ ଇନଫର୍ମେସନ ଦେବେ ସେଇ ପାର୍ଟଟା ଭୁଲିଗଲେ ଇମ୍ପୋର୍ଟାଣ୍ଟ ପାର୍ଟ ଦ୍ୟାଟ ଇଜ ଏ ଲେସନ ଫର ୟୁ ଲାଷ୍ଟ ପାର୍ଟଟା ଶୁଣିଲେ ତାପରେ କହିଲେ ଯେ ନନ୍ ଓଡ଼ିଆ କ୍ଲାଏଣ୍ଟ ତାପରେ ଆପଣ କହିଲେ ମୁଁ ତାପରେ କହିଲି ଯେ ଆପଣ କୋଉ ଲାଙ୍ଗୁଏଜ ତାହେଲେ so whatever you say in court I am sure that I have the authority to respond ଆପଣ କଣ କହିଲେ ଯେ ମୋ ପାଖରେ ଇନଫର୍ମେସନ ନାହିଁ କେସ୍ ଷ୍ଟାଟସ ନାହିଁ କିଛି ନାହିଁ ଆପଣ ହାତ ଟେକି ଦେଲେ ମୁଁ ସେଥିପାଇଁ କହିଲି ଆପଣ ଯଦି ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଆଡଜର୍ନମେଣ୍ଟ ନଉଛନ୍ତି ତାହେଲେ କେମିତି ହବ ତାହେଲେ ଲିଷ୍ଟ କାହିଁ କରାହେଲା ସେଟା କଣ ଲେଖିବି
ସିମ୍ପଲି ଆଡଜର୍ନମେଣ୍ଟ ଆଉ
ସିମ୍ପଲି ଆଡଜର୍ନମେଣ୍ଟ
ମୁଁ ରେଡି ହେଇନି
ସେମିତି ସିମ୍ପଲି ଆଡଜର୍ନମେଣ୍ଟ କିଛି ପ୍ରୋଭିଜନ ନାହିଁ ସିଆରପିସି ରେ କି ସିପିସି ରେ ରାଦର ଏମିତି ହେଲାଣି ଯେ କାଉନସିଲ ସୁଡ୍ ନଟ୍ ପ୍ରେ ଇନ୍ ସୋ ମେନି ଗ୍ରାଉଣ୍ଡସ୍ ୟେସ୍
Page 2.
My lord,
ଆପଣ ମେନସନ କରୁଥିଲେ
my lord, item 11.
10
11.
ସରି ସେପଟେ
11.
ମିଷ୍ଟର ବାରିକ କଣ କହୁଛନ୍ତି ଆପଣ
ମୋ ଦେହଟା ଟିକେ ଭଲ ଲାଗୁନି ଗୋଟେ ଟାଇମ ଟେ ମାଗୁଛି my lord ଦେହଟା ଟିକେ ଭଲ ଲାଗୁନି ତ
ଆପଣ ତ ସବମିଶନ ବି ସବୁବେଳେ ଏମିତି କରନ୍ତି ଆଜି ଯୋଉ ଦେହ ଭଲ ନଥିବ ସବମିଶନ ଇଜ ବେଟର ଦେନ୍ ଆପଣଙ୍କ ଅର୍ଲିୟର ସବମିଶନ
my lord ଦେହ ଟିକେ
ଏ ଯୋଉ ପାରା 5 ପାଇଁ ଦେହ ଖରାପ ହେଲା ନା ଆଗରୁ ହେଇଥିଲା ପାରା 5 ଟା ପଢିଲେ
ନାଇଁ ଦେହଟା ଟିକେ ଭଲ ଲାଗୁନି
ଲାଷ୍ଟ ଅର୍ଡର 5 ହେଲା ପାରା 5 ଟା ପଢିବା ପାଇଁ କଣ କହୁଛନ୍ତି ପଢି ଦିଅନ୍ତୁ ପାରା 5 ଟା ତାପରେ ଆଡଜର୍ନମେଣ୍ଟ ମିଳିବନି ପାରା 5 ନ ପଢିଲେ ଆଡଜର୍ନମେଣ୍ଟ ମିଳିବନି ପାରା 5 ଅଫ ଅର୍ଡର ଡେଟେଡ 5/5/2026 ଯଦି ପାରା 5 ତାହେଲେ ମୁଁ କିଛି କରିବି ସୋ ଦ୍ୟାଟ ଆପଣଙ୍କ ଦେହ ଭଲ ହବ ନହେଲେ ତ ଗଲା କେସ୍ ଗଲା ମୁଁ ପଢି ଦଉଛି ଆପଣ ଦେହ କାହିଁ ଖରାପ ହେଇଛି In response, the learned counsel is apprised of the fact that the petitioner himself is seeking a declaratory relief regarding his relationship with the opposite party lady, and in such view of the matter, whether the learned judge family court could not have granted maintenance. Anyway, the matter being listed for fresh admission is mentioned by the learned counsel for the petitioner seeking adjournment at the beginning of the day's proceeding on ground of personal difficulty. Stop. The learned counsel is apprised of the order dated 5/5/2026, which was passed after hearing the learned counsel at some length. Stop. The learned counsel shall respond to the legal propositions discussed and noted in the order dated 5/5/2026. କେତେ ଦିନ ସାର୍ କଣ ଦେହ କେମିତି ଭଲ ହବ ସାର୍ କେତେ ଦିନ ଲାଗିବ
15 दिन खंडे 2 weeks my lord.
We council 27.
My lord, oblige my lord.
week convention 20 sir. Yes, next.
13 to 22,
Next please.
page 3, 23 to 33,
29 years.
Okay, number 2 to 4, your lordship, the last of the notice has been issued. Take 2 weeks time to file counsel.
Petitioner को अछंती पण opposite party पे just inform me let us see whether राजी ही जिवे but at least he should not come later and say that I do not know. मार्क करथे हम देखिबा कोन होची केते केबे आसीबो 28 टा sorry 29
we council 27.
देखो recruitment matter
No, your lordship.
promotion
Loan has been issued.
loan
Yes.
you are appearing for OPSC
No, appealing for.
corporation अच्छा अच्छा केते 2 weeks time for counter केबे कहले Mr. Barik
37.
27 रहबो we commencing 27 yes I marked that so that is why I was thinking that it is a case you have power Abhinash showing you have power
Yes, sir.
so let him come it is not like this but if you can make him a call please do that so that I can pass the order ଆପଣ ପ୍ରକାଶ ମିଶ୍ରଙ୍କୁ ଫୋନ କରନ୍ତୁ ଏଇଠୁ ନେଇ ଯାଆନ୍ତୁ ପେପରଲେସ୍ ରୁ ତାଙ୍କ ନମ୍ବରଟା ନେଇକି ଫୋନ କରନ୍ତୁ ଦେଖନ୍ତୁ ଓକିଲ ନାମରେ yes next
Page 4, 34 to 38,
Item 38, my lord. 38,
ଆଜ୍ଞା 37 ସାର୍ ମେନସନ କରୁଛନ୍ତି ମିଷ୍ଟର
38, sir.
ପାତ୍ର
35 my lord. On the last
35 sorry 35
35 my lord.
Hmm.
Last occasion notice was issued. I am appearing for the respondent opposite party husband.
Mhm.
Needs to 2 weeks time to file objects.
ঠিক আছে সেটা বি after notice matter does they come around 3 and say that I mean they are otherwise preoccupied but expecting that it will be taken up please inform date କରନ୍ତୁ
we council 3 year.
same request say
38, my lord.
get the
I see.
okalatnama call him and inform him
Yes, sir. Lord.
Next week, my lord. Enhancement or maintenance, my lord.
38 sir 38 कौन चाहते सर मिस्टर दास
Next week, my lord. It is enhancement or maintenance, my lord. Opposite parties received notice but didn't appear in the court.
से appear करना है क्या
He has received notice, my lord. Tracking report is there.
I'm sorry actually I could not hear you कौन गोटे कहले sorry please repeat
Tracking report is there. He received notice and it didn't appear, my lord.
अरे receipt notice नहीं delivered लिखा है जे अपन तो receipt notice कोशन that's a
Delivered.
problem there
Notice there,
in
sir.
that Mr. Guru was arguing that Sambhalpur matter where it is difficult to ascertain that who has received
Then next week, my lord.
ठीक है से awaiting appearance था
Oh, sir, sir.
पाउचंती ना
All right, my lord. All right. Thanks.
न पाइले कौन कहिबे करिवे
Yes, my lord.
30 डेट कर दूं
We council 10.
38 लगती हो तो मिस्टर अश्विनी कुमार दास for the petitioner the matter is listed for hearing under the heading for admission stop this stop the matter is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding stop the office note indicates that AD of the notice and sole OP not received awaiting appearance of the OP the matter shall be listed for admission in the week commencing
10.
10/8
Item 1,
finally the pass over
item 4,
May I
you are
please,
Mr.
your lord?
Patjosi
Yes, your
Mr.
lord.
Akash Kumar Patjosi
Yes,
for
sir.
the
For the appellant, your lordship.
Mr. Mahanti,
Married.
she's a lady. Upon instruction nebe. I mean, I don't know whether copy has been served. Copy served करचंदी.
Yes, yes, yes.
देखो
Formal instruction.
formal instruction. Now again, you have also become lighter also. ठीक है. Mr. Akash Kumar Patjoshi for the petitioner. Mr. Prem Kumar Mahanti, additional standing counsel for the opposite party. IA, but I can't give the state the reason. IA number 74 of 2025 has been filed for exemption of court fee. Copy has been served on the learned. But you are right, Mr. Mahanti. You can intimate them that court fee needs to be exempted, whatever. You are right. So it's better that the respondent should be made aware of that. Only learned the additional standing counsel. The learned AC submits that he shall obtain necessary instruction. Stop the matter shall be listed for fresh admission in the week commencing.
Odisha.
27.
Item 5.
Your lordship, similar matter.
Exempt. Same order.
Much of village, your lordship.
Today I 5 73 of 20. Copy served, Mr. Mahanti?
Yes.
Yes.
Item 6.
Please, your lordship. On behalf of Mr. Jesus.
I agree on behalf of Girish Chandra Sahoo, C. Sahoo for the petitioner. Yes, Raiguru.
Yes, ma'am.
Yes, Raiguru on behalf of G. C. Sahoo for the petitioner.
The sole grievance of the petitioner is that prayer of the petitioner in this application to transfer the GR case to Dhankanal from SGM Bonai to SGM Dhankanal. It is the case or
Provision transfer
the
provision ठीक थी वो कौन का reasons of seeking transfer
reason it is 350 kilometers away from the village.
Provision
it will be convenient.
It is otherwise convenience of the accused facing trial. এটা কো প্রয়োজন আছে এটা তো আপন ইয়ে কর দেলে সেকশন 24 সিপিসি Doctor, I take you very seriously, Mr. Raiguru. If I start dictating the order, it will be worse than a laughing stock. Sir, CRPC defines the jurisdiction, cause of action. All those things are there. Which case in CRPC is transferred? 125 only. 124, now 144.
Yes.
But in a criminal trial, you are saying convenience of the accused.
As it is 300.
The accused has chosen to commit a crime 350 kilometers away from home. Then what about interstate crimes?
May submit, madam.
May I submit? You have to answer also. It is not a one-way.
At that time, madam, the wife and the husband, the present petitioner, residing at Koida, madam. That's
what residents କଥା ପଚାରୁଛନ୍ତି. Which provision in CRPC will help you? ସେଠି ତ ଭାବିବେ. You chose to commit a crime at Koida. You are the accused.
Matrimonial 498 case.
498 where it was committed?
Koida PS.
Koida PS. FIR is Koida PS.
Koida PS.
So the SDGM Koida ଆପଣଙ୍କର ସେଟା ହେଉଛି କଣ ଅନୁଗୁଳ. Koida is in
Koida hoji Bonai Sundargarh.
So how this court will confer jurisdiction where the accused stays after committing 498A, the accused stays in Cuttack.
The informant died in cancer, madam. Informant, the wife.
How does it help you, sir? If it dies or if it abates, it's abates. Then still worse. That's a still worse argument.
Abate habon eta.
Obviously, crime abate हुएनी. आपण आर्गुमेंट कले बेले मु कहली ना लेकिन आपण मिस्टर सडंग को भलिया कहली अबेट हबनी
नहीं इन्फॉर्मेट
पचारथिली कि जे अबेट हबो कि नहीं आंसर देबी बोली आपण कहले जे से इन्फॉर्मेंट हैज डाइड मे बी इट डजंट मेक एनी सेंस आपण काहे कि कहले मु सेत पे कहली इफ इट अबेट्स दैट्स डिफरेंट थिंग इन्फॉर्मेंट डाइज हेले कोन हबो से ट्रांसफर हे जिवो
हमको जेहेतु सेटे स्वामी स्त्री रहउथले
देन ही मैरिड अगेन
married after death he married.
Married again. So let him commit a 498 at now at Hon'Ble, Dhekanar. It will be tried at Dhekanar.
My
First 498 was committed in Bonai.
yes, ma'am.
The victim dies. Now he marries for the second time.
The victim dies in cancer, ma'am.
Again,
He was also treated.
suppose the victim dies due to heart attack.
Yeah, haba.
What is going on since morning? I don't understand. About transport bill, bilkul prepare ही नहीं थी.
नहीं, prepare है क्या?
Then what kind of submission you are making? He marries for the second time. He wants 498. For that, he has to again commit 498 at Dhekanar. Not by court direction. The earlier matter is to be transferred. Hard not at counsel
Withdraw.
for the petitioner.
Withdraw.
No, it has to be on merit. I am not wasting time, sir. This discussion is not wastage of time. The petitioner faces trial being accused in GR case number 434 of 2018, corresponding to COIDA PS case number 63 of 2018. For that, you have to amend. So there should be some provision in the statute so that convenience of the accused, or where if the accused marries again and stay at a new place,
A new place, it is his native village.
new
ma'am.
place, whatever. He chose the complaint was there for 498 days. Well, research କରିବାକୁ ପଡିବ ଆପଣଙ୍କୁ ଏ jurisdiction develop ହେଇନି. That is my reading of law. accused ଯୋଉଠି ଚାହିଁବ ସେଠି ହବ, ସେଟା ହବନି. Because the standard, the principle of law is that where the offense is reported. Otherwise, it's difficult. COIDA PS case number 63 of 2018, now pending before the lauded STJ Bonai, Sundargarh. Transfer like that, right? The petitioner wants by filing the TRP CRL 6 transfer of the said GR case number 434 of 2018 to the Court of Law at SDJM Dhenkanal for the interest of within court for the interest of justice. Court ends. The Lord Counsel for the petitioner was requested to apprise this court under which provision the choice of the accused in a trial is the criteria for transfer of the criteria for directing transfer of the trial. Lord Counsel for the petitioner submits that now the petitioner resides within the jurisdiction of Dhenkanal, STJM Dhenkanal. Due to the distance between Dhenkanal and Bonai, the matter should be transferred to Dhenkanal. Stop para. The Lord Counsel for the petitioner is apprised of the fact that when the crime was committed, when the crime is reported to have been committed at Bonai, the court at Bonai jurisdiction at COIDA, and the FIR was lodged at COIDA PS. As per the provisions contained in CRPC / Bharatiya Nagarika Suraksha Samhita, the matter is being tried at the appropriate court. It is further submitted by the Lord Counsel for the petitioner that the accused faces trial under provision for alleged offences committed under section 498A of IPC. The complainant wife died, unfortunately passed away with cancer. After that, the petitioner has remarried and stays at Dhenkanal. Stop. The Lord Counsel for the petitioner is also apprised that the said aspect, the subsequent developments as narrated by the petitioner cannot be a ground to transfer the trial to Dhenkanal. Stop. At this stage, the Lord Counsel for the petitioner files files memo of date seeking withdrawal of the petition. Accordingly, the petition is dismissed as withdrawn. The memo is taken on record. The memo states thus. Memo is taken on record. Scan copy be updated. After लिखें the petition starts dismissed as future. Problem. Yes.
Item 8,
So Pranab Ranjan Chatwai for the petitioner.
May I please your lordship. The petitioner being the wife in law seeking transfer of the CP case number 89 of 2025 from the Court of Law and Judge Family Court Puri to the Law and Judge Family Court to Bhubaneswar, my lord.
Sir, what is the CP?
My lord.
What is the CP for restitution of
CP
conjugal rights?
My lord.
Sir, what is your stand in the CP? You want restitution of conjugal rights or not?
My lord, yes.
You want restitution.
Yes.
Then why you want transfer?
Well, transfer in some my lord, she is a destitute lady having one minor son, my lord. And staying with us, she had driven out.
Under which provision, when a section 9 application is filed by the husband
My lord.
in court of jurisdiction, because the wife is destitute and has a minor son, can be transferred. Which provision?
But I am saying another one.
Why I am saying no? Provision टा कोई भी. ମୁଁ ବି ତ provision ଜାଣିଛି ନା କଣ ଆପଣ କହିପାରନ୍ତିନି କୋଉ provision ରେ ସେଟା ଅଛି. You must understand that I have to pass a order.
My lord.
Your stand is that you want restitution. So go to the court and say that the court restitution be allowed. So that the purpose is this TRPC is a aimless litigation. She can't go to the trial court, comes to High Court. Does it help her?
But
Or unnecessarily prolongs the litigation? Other aspect. For counseling, there is a provision in Family Courts Act or Hindu Marriage Act, and it's mandated. That cannot be done. Sooner the counseling, better the result for both the parties. When you talk to your client, when she says that yes, I want to resume matrimony, she might have some reservation. So by counseling, something may happen, which will endure to the benefit of both the husband and wife. So that is the concern I am expressing. And it has to be expressed through you because you have an onerous responsibility. Here, you also act as a guide and philosopher, apart from being a lawyer. You have to advise.
But because
when she receives notice, goes to the lawyer says, "Upon jaan to High Court re file karibe, taku stay kariba." What for? Because you see, the act is a completely. It's a complete code in the sense it has some provisions of counseling. It has some provisions for taking care of other things.
dispute arose earlier, my lord, that was settled before the police station, my lord. Still then, my lord, he assured the petitioner, my lord, to live on peacefully. But again, assaulted, for which now she is staying in her father's house.
Correct, sir.
And with some
For that, if she wants to stay with her husband, court cannot compel her not to stay. Your answer is that she wants to resume the matrimony.
but she has been driven out. That is the whole problem, my lord. He will not feel safe, my lord.
Do you understand what you are saying? If you want to resume the matrimony, there is a process. You can tell the court that yes, I want to resume the matrimony, but these are the circumstances which I have been driven out, as you said.
Yes.
I face difficulty. For these reasons, I have to leave my matrimonial house, but I want to stay with my husband. That's in TRPC jurisdiction, those things cannot be done. I cannot initiate a counseling because we do not have counselors. I cannot direct for any other order, like to give them a chance for staying together. Cannot be. And obviously, it is a wastage of time also for both the parties and as well as the court.
And DP proceeding is also
How
pending.
many cases you have filed against the husband?
DP proceeding is also
Only one.
one.
Seeking financial assistance.
My lord,
Where it is pending?
Bhubaneswar.
You were transferred from which place to which place?
Puri to Bhubaneswar.
You talk to your client.
Right.
By simply accepting the brief, please
Annexed
talk to the
to
client.
the DP proceeding petition CMC 527 of 2026, wherein notice has been issued to the
Sorry, CMC?
CMC number 527 of 2012
Provision 125.
of the
12
DP.
times.
My-
Kohile. I got that. I told you that for seeking
12
financial
of the
assistance. I got that. Take notice.
my lord.
Take your seat and dictate the order. The petition under section 24 of the Civil Code of Civil Procedure has been filed by the petitioner seeking transfer of the CP number 89 of 2025 pending before the Court of Learned Judge, Family Court, Puri, to the Court of Learned Judge, Family Court, Dash English 2, Bhubaneswar. The said CP has been filed under section 9 of the Hindu Marriage Act, seeking by the husband in the marriage opposite party, seeking restitution of conjugal rights. After notices are issued by order dated 7/7/2026. What is the status of the CP?
Pending is not appeared.
Eh?
CP is now pending. Notice has been issued, but she has not appeared.
She has to appear.
Right.
She has to appear. She got Rohuchundi Bhubaneswar. That is your case.
Bhubaneswar Huchavi.
So,
Balipatna Thana under Bhubaneswar.
by the Learned Family Court, the petitioner has chosen not to appear in the said matter and has filed a TRPC seeking transfer. This has been issued and sufficient on the petitioner. To support the prayer of transfer, it is submitted by the Learned Counsel for the petitioner that the petitioner wants to resume the matrimony, but due to the circumstances and difficulties faced by her, she had to leave her matrimonial home and company of the opposite party. She has a court Bhubaneswar ki tangar bapa
Balipatna.
अरे कोर्ट रोचन पचरा होनी कहा संगा रोचन पचरा होची
भाई पाखर बापा मर जाइसिन तेनु भाई घर बापा.
It is submitted that after her marriage has gone into rough weather, she stays with her brother at Bhubaneswar along with minor child born from the wedlock. So it is the Learned Counsel for the petitioner for the refers to the CMC number 527 of 2026, copy of which has been filed by the copy of which has been annexed to the application marked as Annex 2. To submit that, the petitioner has also filed a application under section 12 of the जो 12 application टा आपनकर जो report हेतिला family जोटा कोन visit report
आज्ञा
हेतिला सेटा
मु आनी मिनिस्टर नाही
केमते आपण कहि दोछन
फाइल हेछि
ना
नोटिस
आपनकर जदि डोमेस्टिक वायलेंस टा हला पुरी रे
हां सेटा
बालीपटना रे केमति फाइल हबो
ना बालीपटना भुवनेश्वर बालीपटना अंडर जुरिडिक्शन आछि भुवनेश्वर एसडीजेएम अंडर आछि
कोन बुझछन कोन पचरा हला कहउछन उत्तर दोछन डोमेस्टिक वायलेंस टा कोठी हेतिला
डोमेस्टिक वायलेंस
हां alleged occurrence of domestic violence
मैलर
where it happened
सेटा तांको ससुर घरे
कोठ सेटा
मैलर शिशो अंडर गोपीएस
सेटा केसो लागला आपण बुझे आपण so how it can this court has jurisdiction only for alleged only section 12 of the Mubuni ja kuch na
The petition will also write the application number
12 of the PWDV Act alleging domestic violence against the members of the family of the in-laws, though at Bhubaneswar file korchandi. Before kordiyantu Learned SDJM into bracket O Bhubaneswar, which is pending adjudication. Stop. However, it is noticed that the alleged occurrence of the domestic violence is stated to have happened at CISO under the jurisdiction of Go PS in the district of Puri. Stop. Para. Issue notice along with this order. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 or 5?
5 days.
Within 5 working days. Returnable date be fixed to 3/8/2026. The matter shall be listed in the week commencing 10/8/2026. Then IA 185 of 2026. Hard learned counsel for the petitioner. He entered its submissions as noted above. Stop. Issue notice as above. Accept one set of process fee as well as postal requisites. Stop. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that the CP number so and so, pending before so and so, shall be adjourned to a date beyond 17/8/2026, as would be convenient to the learned court in season of the matter, upon a prayer being made for the said purpose. Object certified copy as per proof.
Item 9.
Mr. S.K. Patnaik for the petitioner.
Petitioner is the wife, my lord, filed this application for transfer CP number 150 of 2026 from family court Barampur to Pallakemandi. As because, my lord, the petitioner also filed an application under section 9 of before the Law and Family Judge Pallakemandi. And the husband filed this application 13(1) in the Marriage Act at Barampur.
And she stays at her matrimonial home.
My lord.
I'm sorry.
Parental.
Parental home.
Right.
At
Pallakemandi.
Pallakemandi. The petitioner before this court seeks transfer of the CP number 19 of 2026. Petitioner before this court is the wife in the marriage. That comma C6 transfer of the CP number 19 of 2026.
150.
I'm sorry. Yes. 150 of 2026. Pending before the learned judge, family court Barampur, Ganjam. The CP has been filed by the husband in the marriage gas opposite party under section 13 into bracket I dash capital small a Roman 1 small a of the Hindu Marriage Act, seeking a dissolution of the marriage solemnized between the parties on 24/12/20 and grant of decree of divorce. Stop. It is submitted that the petitioner, after her marriage has gone into rough weather, stays with her parents at Parlakemundi within the jurisdiction of the learned judge family court at Parlakemundi in the district of Gajapati. She has filed an application under section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. The husband being arrayed as the opposite party. Stop. It is submitted by the learned counsel that the in the fitness of the things and in the interest of justice, both the matters have to be tried together. So it is submitted that the wife, the petitioner, finds it difficult to attend the matter at Ganja. Stop. Issue notice along with this order. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration. And proof of delivery shall be filed within 5 working days. Returnable date be fixed to 3/8/2026. The matter shall be listed for orders. Notices which orders to assure sufficient. Shall be listed for orders in the week commencing 10/8/2026. IA number 176 of 2026.
Right.
Hard Learned Counsel for the petitioner. He reiterates his submissions as noted above. Issue notice to the opposite party as above. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that the CP number 19 of 2026, CP number 150 of 2026, pending before the Learned Judge, Family Court, Ganja, Family Court, Berhampur, Ganja, and CP number 19 of 2026, pending before the Learned Judge, Family Court, Paralakhemundi, Gajapati, shall be adjourned to a date beyond date kepe konta hai 17 beyond 17/8/2026, as would be convenient to the Learned Courts in season of the matter upon prayer being made for the said purpose. Urgent certified copy as per be issued as per.
Item 12.
Ms. Manasi Mahapatra for the petitioner. The Learned Counsel for the petitioner was heard at length on 5/5/2026. The propositions of law were discussed and noted in the order, in the said order. Stop no comma which is reproduced here. Reproduced one. Today the matter being listed for fresh admission is mentioned by the Learned Counsel for the petitioner, and memo of date is filed which states thus. The memo shall be taken on record, scanned copy be updated. Stop. The petition is disposed of accordingly. Yes, next.
Item 13.
Yes, please. You're Mr. Nanda. So why you are not arguing?
This is not.
Mr. Vijay Swarup Nanda for the petitioner. Mr. D.N. Lenka, additional government advocate for the opposite party. For OP number 1, 3, 4 and 5. 1, 3, 4 and 5. Have you sought copy to on corporation? Corporation has a panel of counsel. It will be better when you file so that helps you. But they will obtain instruction like Mr. the Learned AGA.
Yeah, another thing, my lord, the deputy DRCS and ARCS should be made party because they are the persons registering the farmers.
Take note of that. What your Learned senior is saying is not against you. Yeah. Because if you allege inaction on part of for not registering, then obviously the authority has to be made a party. By making the higher authority or any other authority does not help you. You may make them, but registrar is not the registering authority, then how he will answer? It's not a jurisdiction also. That is the point he's making.
That is also mentioned in page 26.
Yes.
DCRC and ARCs.
Thanks, Kalan. The Learned Counsel for the Petitioner 6 accommodation to advance arguments. Accordingly, the matter shall be listed for fresh admission in the week commencing 27. By that date, you complete everything. You can implead and other things. Yes, next please.
Item 14.
Mr. Samantre. Mr. Shalendra Samantre for the petitioner.
14,
Yes.
29 petitioners have come before lordships challenging the continuance of the governing body of the registered society. Here there was no election conducted and they are still continuing. After 31st April, my representation to Annex 3 is pending with the ADM. In fact, what has happened, there are about 100 members.
He is the appropriate authority. ADM is the appropriate authority.
Again, he has received it. But could your lordship kindly see ये जो WhatsApp message पठे दिले तापर तक delete कर दिले 15 दिन notice दवा का था. Under the bylaws, 15 days notice is mandatory to hold the general body meeting and the election. Now what they have done, they have given only 5 days. 5 दिन notice है कि WhatsApp पर दे दिले, election was conducted and they said that no, we'll have this governing body should continue for another 1 year. And the bylaws will be amended, that will be taken care of by the sub-collector, we'll meet them. But how can you continue after 1 year? It's mandatory that the elections will be held every year. If your lordship will have a look at this page
But
31.
you have not challenged any order.
Sorry, no order has been passed. If your lordship look just for a minute,
But
page
without
31.
Mr. Samantra, with your vast experience, and so many things I've learned from you also. But kindly look at the prayer. Kindly read the prayer at page 9.
I'm conscious.
Declaratory relief in a read jurisdiction is I am made to learn that. I have power to set aside very wide powers.
I will meet
very
that.
wide powers.
I will meet that. But for the moment, kindly see
Because kindly read the prayer. Then we can go to the annexure which you are aggrieved.
I'm conscious. Unhappily drafted, unhappily typed.
Sir, unhappily drafted is the what you call it.
That is no excuse.
It's the prerogative of lawyers. We go on drafting,
That's
amending.
no excuse.
But I cannot make out anything from the prayer because I have to find out to either because I'll be exercising what mandamus. To exercise mandamus, I have to find a duty on somebody to act. Apart from that, I can set it aside.
Why I'm pressing for lordship? This election was held in a most surreptitious manner. The facts.
Mr. Samantre, it's not a matter of speech. It has to be there in the pleadings. If election is held surreptitiously, you can say that let the election be set aside. Correct. The result has to be declared of that election, whatever you want to set aside. Now, kindly look at the prayer. It is not that I am not there with you. I am trying to understand what you have challenged and look at the prayer at page 9.
Why it have declared that the continuance of the governing body of the society, Kharabal Estate to Union Parishad, as illegal and to be set aside because they are continuing beyond 1st of April. And further, be pleased to appoint an independent election officer. Elections to be held by secret ballot.
All these things have to be very specific. There can't be a non-specific. Is there a prophylactic jurisdiction like agua vaccine de dele so ठीक ठाक होगा? सेमती किसी नहीं. Even crimes are also not prohibited. Rather, the crimes are punished.
Here, what they have done.
So, can anyone say that that somebody is a victim of crime? It is his or her fundamental right is there that to be taken care by state. What notice I will issue?
In fact, we did not know that whether election has been held or not. No, it is on
who am I to ask them election election ହେଇଛି କି ନାହିଁ?
No.
ଆପଣ ଯଦି ପଚାରିବେ ତାଙ୍କୁ not Lenka, Mr. Lenka is ଯାହାକୁ ବି ପଚାରିବେ election ହେଇଛି କି ନାହିଁ and provide the election result. That you can challenge. But ଆପଣ ବର୍ତ୍ତମାନ ମତେ କହିଲେଣି ମୁଁ ପଚାରିବି election ହେଇଛି କି ନାହିଁ, do not know. continuance. So continuing by which order?
Your
If you are saying the term is over, if the term is over,
page 28. He notice resolution that was not circulated, not given to anybody.
sir, this can't be in void. ଆପଣ ଯୋଉଟା challenge କରୁଛନ୍ତି, bring that on record.
This is the
ଆପଣ ଯୋଉଟା ଚାହୁଁଛନ୍ତି also, if you are agreed by something, say continuance. So by which order they are continuing? Bring that on record.
page 28. This is the resolution passed on
Then
20.
resolution ଆପଣ ମତେ ପଢାନ୍ତୁନି. My question, I try to make my questions very incisive and specific. So ଆପଣ straight away କୁହନ୍ତୁ କୋଉଥିରେ ଆପଣ ଚାହିଁଛନ୍ତି.
Page 28.
WhatsApp cannot be entertained.
If the lordship will see the synopsis, it is made clear, but not mentioned in the prayer.
Synopsis
It's a purely private dispute between the,
obviously private dispute re ଆପଣ unless the administrative authority, if it has committed any illegality or passed a wrong order or has exceeded jurisdiction, these things obviously you can challenge.
At page 30.
Mr. Samantara, you have a look at it and discuss with whoever is briefing you.
But could your lordship have a look at page 31?
28 ରେ ଆପଣ WhatsApp message ତାର basis
This WhatsApp message says that
sir WhatsApp message ରେ official जोटा सेटा आपण मत देखैबे WhatsApp message କଥା पढिनी. You have to say WhatsApp message by which authority? Because you see WhatsApp message can be sent unofficially and definitely it is unofficial. Anyone can send WhatsApp to anyone. So you have to show the order you are aggrieved.
this is a society where there are 100 members. Now they have made an inner coterie and the election was allegedly held after 5 days.
Coterie is not prohibited. Those are irrelevant,
Fine.
considerations.
Fine.
Sir, you straight away come to by which order you are aggrieved.
There is no order.
Then I have to dismiss it. I have no choice. Unless you challenge the order, this is not a fishing expedition. I'm not fishing finding out what has happened.
My only grievance
The petitioner who is aggrieved must know how he is aggrieved. And this is cause of action.
We are aggrieved because there was no election.
Sir, it's not a matter of speech, sir. I have been patiently hearing you, repeatedly telling you that I'm impressed with your speech, but show me the order by which you are aggrieved. Or they are continuing, then by which order? Then you are showing me WhatsApp messages. WhatsApp messages cannot be basis of issuance of notice. It is your choice, sir.
ଏହିପରି ଭାବେ ନିମ୍ନଲିଖିତ କାର୍ଯ୍ୟ
କୋଉଠି କୋଉ ପେଜ ରେ ପଢୁଛନ୍ତି?
page 28.
WhatsApp message ପଢନ୍ତୁ ନାହିଁ ପରା କହିଲି.
ନାଇଁ ସେଟା ସା delete
Your
କରିଦେବେ.
reliance on WhatsApp messages cannot be a ground for court to interfere. You have to show the order. That's it.
This is the
passing order, Mr. We're wasting time, Mr.
Sir,
Samantara.
this is the order.
Either Mr. Samantara good sense has to prevail, but the order cannot be my order should not be nonsense. That I rely on WhatsApp message. Then
my submission of this WhatsApp message says that there was a resolution.
Sir, you should not. Being a seasoned lawyer, you should not have relied on WhatsApp messages. You should have asked them, bring the order. That you should have done.
When we questioned them,
my
only submission to Lordship is
was heard at length.
This Annex 3 may be considered. I moved the ADM that these are the irregularities committed.
Consideration jurisdiction. You see, if they have to do it, I'll direct them to do it. Consideration, it's not.
No.
You have to first establish why you are agreed, who is the authority, that much. So that is the first question.
My entire grievance is before the ADM. With the authority.
I'm not directing him.
They have received.
So you go and meet the ADM. I'm not his subordinate.
No, we have.
After ADM, आपण collector देखा करिवे, collector पर RDC को पर secretary, तापर chief secretary, तापर high court आसीवे.
What observation did you?
No. Yeah, I'm not here to assist the ADM to do his statutory work.
No, inaction, state inaction.
I can't go down to that level.
State inaction.
Upon the action ही नहीं.
Sorry.
You are saying inaction. I'm asking you for the last 15 minutes. कोटा inaction देखान्तु. You are struggling there.
Page 32. They have received it. My complaint.
WhatsApp message केते थोड़ा मना करिवे आपनको.
No, set up WhatsApp. Set up the complaint. Set up the grievance before the ADM.
Sir, as you are unrelenting, the court can be very well reasonable also. You are unrelenting, I am reasonable. That's it. I'll pass the order. the petitioners have stated to be.
In a similar situation regarding election, the matter went to the Supreme Court from this court. Writ appeal ହେଇଥିଲା ଯୋଉଟା my learned friend
So I have also laid little law also.
truck drivers.
There is no such
Keonjhar-
there is no such jurisdiction. There is no such jurisdiction to be exercised by court without the basis of presenting the court how you are aggrieved and why you are aggrieved.
We are agreed by non-holding of election.
So that
Please print it.
where you are saying.
ଏଇଟା ହଉଛି ରେଜଲ୍ୟୁସନ ତାଙ୍କର।
ଆଜ୍ଞା WhatsApp message କେତେ ଥର ମନା କରିବି ଆପଣ?
No, this is the resolution which was circulated through WhatsApp.
ସେଇ ରେଜଲ୍ୟୁସନ ଟାର ଅରିଜିନାଲ ଟା ଆଣିବେ କେତେ ଥର କହିବି?
Original.
Dismissed.
So leave
No,
file the original.
nothing.
Original, they
Sir,
are
you
not
have
producing.
wasted the time. My time is precious. I can't go on assisting you because your learned junior is not assisting you. But it is not that I'm ମୁଁ ତ ଶୁଣିଥାନ୍ତି ଚୁପଚାପ without interacting I could have passed an order. Same order ହେଇଥାନ୍ତା. Why I'm interacting with you?
Because they did not hold election in Keonjhar Truck Drivers
Sir,
Association.
that
not be
act
appointed.
of not holding up election, you are circulated WhatsApp message, you are presenting before the court. Who has issued the message? Why it has been messaged? You
And that was
you
the-
get that copy. Who has sent it? Whatever. The petitioners have stated to be members. से कौन अछंती?
Members of the society.
Good लिखछंती. Your petition is so dark that in fact the outside has become really dark. It is so clouded and shrouded in mystery. It is a struggle for a very senior counsel and much more a struggle for the judge.
Para 3.
Para 3. Para 3. We are members of the association and we had no notice.
The petitioners have described themselves in the writ petition thus. Quote, the petitioners are bona fide members of the Society of Kharabela Estate Unnayana Parishad, Nakara, Bhubaneswar, registered on 16/3/2025 by the ADM Bhubaneswar under the provisions of the Odisha Cooperative Societies Act. Para 3 देखिए इधर वर्षा भी है Act 1960. It is submitted by the learned counsel for the petitioner that the society is governed by its registered bylaws under the Societies Registration Act, which mandates periodic democratic election of the society.
Annex 1 is the registration certificate.
Not necessary. That is not your argument that it is not registered. The following prayer has been made in the writ application. Page 9, paragraph. Prayer लिखी हुई. Our motive is therefore humbly prayed that goes up to maintain fit and proper for the ends of justice. Perusal of the prayer. From perusal of the prayer, it is apparent that the petitioner has not mentioned how the petitioner is aggrieved by the action of the authorities or by which order they are aggrieved. To grant opportunity to the petitioner, the learned counsel was requested to apprise by which order the petitioners are aggrieved. It is submitted that the petitioners are aggrieved by the continuation of the governing body of the society which was registered on 16/3/2025. That is 15 months earlier. Stop. The learned counsel for the petitioner relies on WhatsApp messages, quote, within WhatsApp, say WhatsApp you got WhatsApp messages which have been printed and reproduced in paper and marked to the writ application as annexed 2. The Learned Counsel again was requested to apprise the source of this message, which indicates which purportedly indicates the meeting at the resolution of the meeting held on 22/2/2026. The Learned Counsel, after much persuasion, agrees to produce the resolution dated 22/2/2026, official copy of the resolution, and shall have the liberty, and the petitioner shall have liberty to produce the copy of the order by which the petitioners are aggrieved. The matter shall be listed for fresh admission in the week commencing. How much time, Mr. Saman?
10, 15 days.
Two
They will not give me.
2 weeks.
They will not give me.
3 सप्ताह में अपन अप्लाई करो तो सी कौन ये चाहूँगे जानना है एक्चुअली एटा क्या बसी की बर मागे पड़ो ताल साकुर देबे कारण ये तो आमे तो बुझी पनु कोन एटा वी कमेंसिंग 27/7 20/7 हेले भी हो 20/7 ना 27/7 मिस्टर सामंतरे वी कमेंसिंग 20 ना 27
এটা ওড়িশা সোসাইটি নেই, সেটা হচ্ছে সোসাইটি রেজিস্ট্রেশন অ্যাক্ট 1860।
হ্যাঁ,
এটা লর্ডশিপ ডিক্টেটেড that ওড়িশা কোঅপারেটিভ সোসাইটি, নো সেটা ভুল,
সেটা ভুল।
वो तो डाकिनी से
হ্যাঁ হ্যাঁ,
ভুল লিখছি।
প্যারাগ্রাফ 3 ରୁ লর্ডশিপ লিখেন
एग्जैक्टली
that is সোসাইটি রেজিস্ট্রেশন অ্যাক্ট 1860।
on Korea से तो उसमें डिक्टेशन देने अवॉइड कोट करार कारण हो जैसे इटा तो एटलीस्ट कोटेशन रे ता कहले अपन देखिए पारा 3 बट थैंक्स फॉर पॉइंटिंग इट आउट आरंभ लेखो दैट शोज द why it is so dark. You have to correct it right now. The Learned Counsel for the petitioner submits that. Ask your Learned Junior to do it. That inadvertent typographical error has crept into the paragraph 3 of the writ application where the Society Registration Act 1860 has been wrongly mentioned as Odisha Cooperative Society Act, 1960. Stop. The Learned the prayer seeking correction of the said typographical error is allowed. The petitioners shall carry out the necessary correction in the physical copy of the writ application, which shall bear his initials to be countersigned by the court master. The copy served on the Learned AGS shall also be corrected. Stop. Scanned copy be updated. Stop. Tapore ita likhi order. Yes, Mr.
15.
My lord, on behalf of Kuldeep Panti, there's some personal difficulty. I pray for adjournment.
15. Mr. A. Das for the.
Yes, sir. Somyaranjan Das.
Mr. S. Das on behalf of Kuldeep Panti for the petitioner. Adjournment is sought for by the adjournment is sought for on behalf of the Learned Counsel for the petitioner. ଆପଣଙ୍କର ଯଦି ଓଡିଶା ଆମେଣ୍ଡମେଣ୍ଟ କଣ ଥିବ ଆଗ ଲେଖିବେ सोसाइटी रेजिस्ट्रेशन एक्ट 1860 रेड विथ ओडिशा अमेंडमेंट हेले ठीक हो तो मु जानि बट काइंडली चेक दैट मे बी ता भीतर कोन ओडिशा रे कोन हितिबो इंस्टेड इतो कोऑपरेटिव सोसाइटीज एक्ट this will have the personal difficulty as prayed for. The matter shall be listed in the week commencing
27 sir.
27
Ma'am.
yes, next
16.
Permitted to place on behalf of Mr. R.K. Malik, your lordship.
You are Mr. Das.
Mr. Mahanti.
I'm sorry.
Vibhu Prasad Mahanti.
Mr. Vibhu Prasad Mahanti on behalf of R.K. Malik for the petitioner.
Here, my lord, petitioner is the husband challenging the interim order under Annexure 1 passed by the learned civil judge Senior Division, Bhanjanagar, your lordships.
Yeah.
In Annexure 1,
Yes.
the case is that, my lord, petitioner filed an application under for dissolution of his marriage. And in that case, IA has been filed by the wife, in which the present impugned order has been passed to pay monthly amount of rupees 10,000 rupees, along with a litigation cost of 30,000 rupees. Now, today, my lord, I have obtained instruction from that in the meantime, because the order has been passed to pay the maintenance from the date of its order, which is my lord 7/1/2026. But in the meantime, they have paid a substantial amount in the court.
File that affidavit.
Well, I'll file enough. But
It is submitted by the petitioner hard learned counsel appearing for the petitioner on behalf of the counsel on record. Stop. The petitioner before this court is the husband in the marriage. Stop. He challenges the order passed by the learned judge, learned civil judge into brackets Senior Division Bhanjanagar. In IA number 02 of 2026, arising out of MAT 35 of 2025, MAT 35 of 2025, to order लिखले नहीं की, order dated 1/5/2026 package, order dated 1/5/2026, passed in IA number 02 of 2026, arising out of MAT 35 of 2025. The IA was filed under the provisions of Section 24 of the Hindu Marriage Act. Arising out of the MAT case filed by the husband in the marriage, seeking dissolution, husband in the marriage under Section 13.
Yes, sir.
The 13 of the Hindu Marriage Act, seeking dissolution of marriage solemnized between the parties on 1/3/2017. Stop. It is submitted as per the direction of the Learned Judge Family Court in the Section 20 in the application under Section 24 of the Hindu Marriage Act. The petitioner has been paying the maintenance pending delight for maintenance of the wife and child, one from the wife and the child born from the wedlock, at the rate of rupees 10,000. Stop. They submitted that given some time, the petitioner shall file the affidavit indicating the amounts already paid. The petitioner shall file affidavit indicating the date of payment, mode of payment, and amount of paid, stating the same in brief. Affidavit shall be filed by
6th of July.
by 6/7/2026. The matter shall be listed for fresh admission in the week commencing 13/7. 13/7 6 to 9 करते 9 की 8 को.
Yes, sir.
8. Yes, next.
17.
The memo has been filed.
In absence today कर दो बा.
Your lordship will see annexure 4. The state education tribunal has allowed his petition. And
Retired from service से ले कौन होगा? Past benefit पाइबे नहीं?
पैसा थिबे पैसा थिबे.
कौन
And if your lordship kind have a look
memo टा
to,
देखो तो flag 10 रे अच्छी.
yes, memo टा हम पाकर नहीं. Yeah, sir.
तो नहीं.
Memo नहीं.
Just kindly look at ये देखन. Just go to the bookmark and click memo flag 10. इतने bookmark अच्छी था.
Sure.
ଓ ସିଏ ଆପଣ ଫାଇନାଲ ବେନିଫିଟ ପାଇଗଲେ ଆଉ
ବେନିଫିଟ ଗୋଟେ ପାଇଗଲେ ସେଇଥିପାଇଁ
ମୁଁ ଯୋଉ ଷ୍ଟେ କରିଦେଲି ସେଇଟା କମ୍ପ୍ଲିଟ ହେଇଛି
13 matter.
I think Mr. Ratha said this, that Mr. Senior Counsel, Mr. Ratha said that he will obtain instruction, and because of that, this is 24/6/2026. Our say memo रे गोटे कॉपी टा हबो जी सर को देबे कॉपी से कॉपी दम सर देन petitioner none, opposite party Mr. DN Leka HA for opposite parties 2TO24. OP5 none. Presiding officer कौन दरकार?
No.
After Supreme Court direction, they did not be made parties.
Court should not.
13 मसीहार केस था ना सेतेबेले थिला. The matter is listed for orders. Office note refers to the memo dated 24/6/2026. Filed by the learned counsel for the petitioner. Which states thus. Into bracket like there, SIC. It is submitted by the learned AG that he has not been provided copy of the memo. The learned AG is permitted to obtain copy from the court. Obtain a copy of the memo available in the court records to be provided by the court master. Stop. As mentioned in the writ application, as mentioned in the memo dated 24/6/2026, the petitioner challenged the. As mentioned, as stated in the writ application, the petitioner challenged the order. Judgment dated 21/11/2012 passed by the learned presiding officer, State Education Tribunal, Odisha Bhubaneswar, in appeal case number 31 of 2011. Stop. The petitioner was aggrieved as he was in charge headmaster, which was challenged by the appellant into bracket like present OP number 5. So this is going to this.
Petitioner was aggrieved as he was in charge headmaster, which was challenged by the appellant. It's in the appeal of number 5.
Right before the learned education tribunal. The learned tribunal by its judgment allowed the prayer of the appellant dash of OP number 5 by setting aside the order issued by the authority appointing OP number, appointing the present petitioner as headmaster. Stop. The writ application was listed. The writ application was presented on 18/1/2013. it was taken up by the division bench, then having determination, or as it was having determination. What civil bench is it?
Kaptan Singh.
It was taken up by the division bench as it was then having the determination. Entry model ta cooked item. Brief entry model cooked account.
Any promotion will be subject to result of the
code.
That is 29/7/2030. First order.
Note 5. Note 5 je over ଅଛି there. ମୁଁ କିଛି order ନାହିଁ. ଦେଖିଲେ ସେଟା ଏଜି ସାର୍ ଙ୍କୁ ଦେଖା ମୋ ପାଖରେ ଅଛି. ନହେଲେ ସେ ପେପରଲେସ୍ ଦେଖିଦେବେ. ସେଟାକୁ ସେ ତ ମେମୋରେ ଯଦି ଲେଖିଛନ୍ତି ଆଇ ଡୋଣ୍ଟ ଫାଇଣ୍ଡ. ଆପଣ ଦେଖିଲେ ସେଠି ଅର୍ଡର ଅଫ୍ ଫାଇଭରେ ତ କିଛି ନାହିଁ. ପେପରଲେସ୍ ଦେଖିଲେ ଅର୍ଡର ସିଟଟା ଅଛି.
She declared by virtue of this honorable court status quo order was passed and the petitioner was remained as headmaster in charge. In the meantime, the petitioner became retired from service. Hence, the case is in progress. Status quo nahi. Because our order sheet lekha hai any promotion
order sheet match karuni. Kote dekho na court order sheet ta. Eta miluni. Any promotion shall be subject to সেটা তো যেটা भी নাই. Order number 5 is there, 29/7/2013. ସେଥିରେ କପି ସର୍ଭ କରିବା ପାଇଁ ହେଲା, but there is no interim order. So we'll not, we cannot pass that order, but it has to be worded differently. On 29/7/2013. Copies were directed to be served on the lauded counsel appearing for the opposite party. Student master 2 to 4, 2, 3 and 4. The learned counsel for the OP number 5 also appeared and accepted notice on behalf of the OP number 5. Yeah. Though it is mentioned in the memo as indicated, as quoted above, that the petitioner, there is an order of status quo passed by this court. The result of the order sheet does not indicate any such order. Stop. However, as stated by the petitioner, during pendency of the writ application, he has continued as in charge headmaster and he has retired on attaining age of superannuation. In such view of the matter, nothing survives for adjudication. Though the order of the Learned Education Tribunal was under challenge. Was challenged by the petitioner, but the petitioner continued to work as in charge headmaster. Stop. The writ petition is disposed of. Mr. Sharma, your matter, can it be taken up after recess or now?
No, I could not saw the copy in my London. Today I saw the copy.
Copy not served?
Not saw. Let it come some other day.
The matter is listed for orders with noting that copy of the application has not been served. Mr. S.N. Sharma for the petitioner, Mr. D.N. Lenka, AGA for the opposite party. Office note that the learned counsel for the petitioner seeks further time to serve copy within
Today I filed.
within 2 working days. The matters have been listed. The fresh admission, fresh matter.
No, it dispose of matter to recall point petition.
The matters will be listed for orders in the week commencing.
sir.
6-7. The order type will be IA 6 of 2026.
Yes.
Arising out of WPC OAC 4328 of 2015. Disposed of by order dated 11/7/2023.
It I take a porcus.
Sorry?
I take a agucas.
आपने अर्ली चाहूँ थे अपन ना पछरे जाओ परे चाहूँ ओ परे कौन आगु दे 27 कौन आते अपन
27 एक राशि
ठीक है 27 कौन 27 से एक्चुअली 108 है सिर्फ 27 रखो ये जे पर्पस 27 54 अछि सो if it is added so पण आइए कॉपीटा सर्व करो so that he can obtain instruction if button required.
Mature item 1.
No matters for the petitioner of the matter, though the matter is called twice or once when it reached, and again after resumption of proceeding after the lunch, post lunch, to grant further opportunity. The matter matter shall be listed for a fresh admission in the week commencing.
20
6 Okay, your Vice President. Yes.
Item 19,
May I please your lordship on behalf of Mr. B. Samantra, my lord,
Sir, you are Mr. S.P. Das.
and Samarendra Swai.
Mr. Samarendra Swai on behalf of B. Samantra for the petitioner.
Here, my lord, deficit.
Sir, Anshuman, you are there?
yes, sir.
Anshuman Sethi for the appellant, respondent. Appellant, petitioner, respondent, opposite party. आइए हबो रिकॉल टा को फाइल छि कहले
My lord,
what is that recall?
no, my lord, condonation bill. Delay condonation. I will there.
मुझे सेटा एसेंशियल मात्र अच्छा सॉरी
Deficit कोर्ट की
आइए 206 of 2016. The IA has been filed by the appellant, by the petitioner dash appellant, seeking extension of time to pay the court fees.
कोर्ट की already filed, my lord.
Subsequently, court fee has been paid as indicated in the office note. Court fee of rupees 11,830 is paid as noted by the office note dated
2nd July 8. 2nd July 2018.
because July payment है receipt period किसी नहीं है
My lord.
कौन ले as office note like मिलूनी as indicated in the memo dated 2/7/2018 filed on 2/7/2018 along with the acknowledgement slip issued by the computerized filing counter dated 2/7/2018 अच्छी पेपरलेस देखले जान करिए ठीक अच्छे मतलब मु देखी कि आपन डाका कुछ दिख आपन भी जान करिए accordingly nothing survives in the IA for adjudication. The IA is disposed of. IA तापर लिखिबे 207 of 2016. 206 you have been served, Mr. Secretary?
Yes, sir.
ऊपर जो लिखले 206 copy has been served on the Laneta Additional Standing Council. IA has been filed for so and so. Copy has been served. 207 you have received?
Yes, sir.
IA 207 लिखंतो. The IA has been filed for the condemnation of delay in filing the appeal. Reported delay लिखिए. Reported delay of
10 days, my lord.
10 days.
Right.
Reported delay of 5 days in filing the appeal. Issue notice. Upon advance copy served, the Additional Standing Council appears and waves notice. What called instruction never? Formal instruction. He shall obtain instruction. 5 दिन ना जल्दी करो तो. He shall obtain instruction and file response if so advised. The matter shall be listed for orders in the week commencing.
Yes, sir.
Kudi sate.
Kudi sate.
Yes.
Item 20,
High D defect कौन कहले? High D copy not served ना कौन? Mr. Alok Kumar Mahanti. Okay. CGC or Senior Panel Counsel? Senior Panel Counsel for the Appellate Union of India. Appellate to appellate, right? Opposite party blank. Varnandi. Correct. Yes, Lord. Officer Hini. H. A defect has been pointed by the staff report dated 14/7/2025 into quotation 5 into bracket small d. Tapare dot received showing small d. Tapare received showing copy on AG, not filed. Quotations. It is submitted by the learned senior panel counsel. That copy has already been served. The learned additional standing counsel also acknowledges the same stuff. The defect starts complied with. Stop. तब लेकिन तो आइए नहीं मिस केस MC 8 of 2016. The this case has been filed seeking condonation of delay of 14 days in filing the appeal. Hard learned senior panel counsel for the appellants. For the petitioners, there's appellants. In the case, they are the petitioners. Stop. Issue notice to the opposite parties. Requisites for issuance of notice to the R1, to the OP1 dash R1 shall be by speed post with registration and proof of delivery shall be filed within 3 working days. Fixing returnable date to 3/8/2026. The matter shall be listed for orders in the week commencing 10/8/2026. Stop. The learned additional standing counsel upon advance copy served appears and waives notice on behalf of the OP-R2. Copy तो दे दीजिए कहते yes.
21.
এটা ଆପଣଙ୍କର ସମାଧାନରେ ହବ ବୋଲି କୁହାହେଲା ଲାଗିକି ସମାଧାନ କରନ୍ତୁ ଆଜ୍ଞା 21 Mr. Panigrahi. So 21 लिखिए petitioner none, opposite party blank, none appears for the petitioner where the matter is called to grant further opportunity. List in the week commencing. List for orders in the week commencing. 27/7/2026.
22.
So Tushar Kanta Mahanta for the petitioner. Project proponent को पार्टी करछन्ती मिस्टर महंत. Project proponent को पार्टी करिसंती. रहिनांती पार्टी. वो रेलवे कोड पार्टी हिची. तळकोट नकले कोन सेटा हाई कोर्ट कोन सेटा कन्फर्म करिवो ना कोन. सेटा हो से ग्राउंड रे. But now the problem is how to proceed. How the High Court will proceed without depleting them as party. What you are saying is correct. Tala court re nahanti to karnante, but apana to jaha le bhi kariya padibo. Nale this court cannot proceed. Mr. You are Mr. Mahanta? Mr. Yes, Mr. Tushar Kanta Mahanta for the appellant. Mr. Additional Standing Counsel for the R1. IA 456 of 2024. बड़ा इतने दिन हेलानी दौना थी 24 मसियारो देखंतु आपनकर फाइल कले 23 अक्टोबर 2024 केते दिन करिवे कोंतु ताले मासे गोटे मेमो दियंतु काई मेमो देबे मेमो काहे की देबे जो कहली मेमो दियंतु काहे की मेमो देबे बुझिते बट आपण आईए फाइल करछंती मेमो काहे की देबे आपण 23/12/24 रे मागिले एग्जेम्पशन वो आपण एग्जेम्पशन चाहछंती तो कोन आपण भूलभाल प्रेयर भूल हे गला कोन भूलभाल कले आ करेक्शन करे पड़ो पढ़ो तो पारा 4 पढ़ो तो सर आइए होची 456 पारा 4 कौन तो पढ़ो मु पढ़ी देबी ना कौन that the petitioner present now unable to pay the requisite court fee due to financial crisis. Hence, it is humbly submitted that the petitioner will be paid the said court fees at the time of hearing, or who will pay the court fee? Petitioner will be paid. Petitioner बीटा भूल है अपन भूलभाल इंग्लिश से भी सेटा वाला से. And adjourned when this court required. Adjourned when this court required court option नहीं. यदि कोर्ट था ऑप्शन था तो यही परिबो it is statutory and without court fees the appeal is defective cannot be even limitation runs prayer kale honorable court may graciously be pleased to exempt the court fee what kare the learned counsel for the IA likle appeals likle the learned counsel for the petitioner submits that though in the IA at paragraph 4 the petitioner has stated regarding financial stringency and sought for time to pay the court fees. Inadvertently in the prayer portion the petitioner has sought for exemption of the court fees of rupees 12,734.2.25 12,734 टका 25 पैसा. He submits that he may be permitted to correct the prayer in the IA. Koriben na kon chahunchunse. Prayer is allowed. The learned counsel for the appellant, for the petitioner appellant shall or appellant petitioner shall carry out the necessary correction to correct the typographical error. In the case brief of the court, he shall also carry out the necessary correction in the IA provided to the learned state council. ताको दियो से correction कर देबे yes much copy data दे दियो होला. The correction shall carry the endorsement of the learned counsel for the petitioner to be countersigned by the court master. Para though it is not mentioned in the prayer that how much time the petitioner requires. When the application was filed on 23/12/2024 to deposit the court fee, it is submitted by the learned counsel for the appellant petitioner that petition may be granted further 4 weeks. Sumanta, 4 weeks. Yes. For the 4 weeks time to deposit the deficit court fee. Prayer is allowed. The deficit court fee shall be deposited in the registry by by 27/7/2026. The matter shall be listed for orders in the week commencing 3/8/2026. The IA is favored and disposed of. Correction कर ठीक लिखिले हम सेटा कर दियो तो 1 month टाइम की 2 months टाइम लिखि दियो देखो जोड़ा सुविधा आपण करेक्शन करि परिबे Yes, next. How did I say लिखिबे appeal. Appeal रे लिखंतु LAA 47 of 2024. Perusal of the cost title of the appeal as well as the IE indicates that the project proponent of the Khordha Road Bolangir Railway project has not been included as a party staff. As per the law laid down by the Constitution bench of the Hon'Ble Supreme Court in UP Awas Ebong Vikas Nigam, when enhancement of the compensation is sought for, the project proponent has to be made a party and is to be heard. Citation the learned counsel for the appellant shall implead the project proponent as a party in the appeal as well as the IA. Yes.
23.
Steps be taken by the next state. For amendment kari taku anantu. Ba nahale jodi oral prayer karibe. The learned counsel for the appellant makes oral prayer to carry out necessary correction in the cost title of the appeal. But जानचंदी से किए project proponent अपन जानिवा दरकार. So notification में था ऐसेटा 41 रे से notification था ऐसेटा. Subsequent भी था तार थेरे सेटा जदि भूल रे लेखा हबो problem कोन हबो ना नहीं सेटा फिर आउटर again correction करे पड़े. So the already the petition has become rough खाता फिर आउरी का correction नहीं चले. अपन बुझी की सेटा देखंतु. At times it is Indian Railway, it is like my East Coast Railway, it can be but a special purpose vehicle. Like Sambalpur division करे नहीं उड़ा. See, अपन को railway finance उड़ा अलग अच्छी special they bring together certain entities, corporate entities to these are very माने कौन अपन को I mean very what is called finance intensive projects. So special purpose vehicle करी से टंका आनी तब करंती. Acquisition द जति पैसा लोची भावं तो कहते to track development and ये सेवड़ा को बहुत पैसा. So city that there is a purpose they अपन जी पैसा दबो ताकि सुनिया दरकार. So you please check that is so उसे order टा specify करूँगी अपन कला करे memo file करी वे list होगा liberty to mention. ता पर लिख दो liberty to mention. It could be a company like Khordha Road Bolangir Rail Company, jemti Sukinda Paradip Rail Company. Tuguri, they have been made that company is only meant for construction. That construction of that particular railway track. Nothing more, nothing less. It is not constructing everywhere. Project finance is a very complex subject. Oversimplify ame bele bele kar dou. Yes.
Item 23.
23 टा non appeals करी कि same order करती हो तो पानी रही तो 21 same as well. पहुँचे ऐसे ले after appeal date कर दे
36 sir.
ठीक है. 23 36 sir. Yes.
24.
Same. ये जो 27 उड़ा तो 200 इतने पूर्ण मैटर भी नहीं जुड़ा तो ठीक अच्छी मुझे जानी नहीं आई एम जस्ट ब्रिंगिंग टू योर नोटिस नॉन अपीयरेंस होची आपण 12 मसिया मैटर को पक्ष 27 यस 25 मिस्टर सामल
25.
Here, despite repeated orders and reminders, the husband opposite party is not responding to the affidavit filed by the petitioner wife. In the concluding paragraph, though I have stated that he was getting salary of rupees 1,50,000 per month, he was a postmaster in the working as manager post payment bank in the Indian. I filed the document.
So I remember your case, Mr. Sambal, and I also remember your anxiety. So give him a chance and we'll remind him. We'll not wait any further. But usually, as you know, I'm very conservative in.
Absolutely right. They have taken thrice time. They have not appeared.
But usually, since I grant adjournment, last chance, all these things I do. So take another, give him another chance, and then we'll remand it. We'll close it. No difficulty.
ଟିକେ indicate
Yes, yes, yes. I remember that you have been mentioning this matter is kept pending, and you also mentioned the matter of evidence, so all those things. But anyway, on the maintenance matter, it has completely lost its direction. Upon the application process, it's not serving the purpose. ସବୁ ଜିନିଷ ଚ୍ୟାଲେଞ୍ଜ ହଉଛି, ସବୁ ଜିନିଷ ଷ୍ଟେ ମାନେ ନହେଲେ ବି ପେଣ୍ଡିଂ ରହୁଛି ସେଠି।
ସେଠି ବି ସେ appear କଲେନି କି affidavit ଦେଲେନି, କୋର୍ଟ କିନ୍ତୁ ଗୋଟେ dissuade ହେଇ କହିଦେଲେ 7,000 କରିଦେଲେ।
ଆପଣ ସେ ଆଇଏ ଟା ଖାଲି ମିଷ୍ଟର ସରି ଆପଣ ସେ ଆଇଏ ଟା ଖାଲି କରିଦେଲେ ତ ଆମେଣ୍ଡମେଣ୍ଟ କରିବେ ବୁଝିଲା ପରେ ହୁ ଇଜ ଦ ପ୍ରୋଜେକ୍ଟ ପ୍ରପର୍ଟି ଏକ୍ସାକ୍ଟ ଯିଏ ଲୋକ ତାଙ୍କୁ କରିବେ ତାଙ୍କ ସାଙ୍ଗରେ ଆପଣ ରେଲୱେ କରିପାରନ୍ତି ଇଣ୍ଡିଆନ ରେଲୱେ କିମ୍ବା ଇଷ୍ଟ କୋଷ୍ଟ ରେଲୱେ ଯାହା ବି କରିବେ ବଟ୍ ପ୍ଲିଜ ବ୍ରିଙ୍ଗ ଅନ୍ ରେକର୍ଡ ଦ ପ୍ରୋଜେକ୍ଟ ପ୍ରପର୍ଟି ଅଦରୱାଇଜ ଦିସ୍ ୱିଲ୍ ଗୋ ଟୁ ସୁପ୍ରିମ କୋର୍ଟ ଆଣ୍ଡ ଏଗେନ୍ ରିମାଣ୍ଡେଡ ଇଟ୍ ଡଜଣ୍ଟ ହେଲ୍ପ ଦ ପିଟିଶନର and that is a 93 decision. Constitution bench is 93, it is not new also. 93, 96, 94. Yes. This is date of decision. EP 20 October. So 94 decision. So Pendra Kumar Samal for the petitioner, opposite party none. The Learned Counsel for the petitioner refers to the order dated 12/1/2026 passed by this court to submit that after the matter was heard at some length and the propositions as well as the facts were the legal propositions as well as the facts were noted by the said order. The matter has been repeatedly adjourned. He submitted that I just stop with it. The result of the order sheet indicates that the matter was adjourned by the Learned Counsel for the petition, adjourned on behalf of the petitioner on 2/2/2026, 7/5/2026, 18/5/2026, which is also the submission of the Learned Counsel for the petition. To grant grant one further opportunity to the petitioner, the matter shall be listed for kitna number item? 25. For orders in the week commencing 13/7/2026, 13/7 वो तो 20/7
ନାଇଁ ନାଇଁ ତାପରେ ବେଞ୍ଚ ଫେଞ୍ଚ ବୋଧେ ବଦଳି ଯିବ ଆପଣଙ୍କ ପାଖରେ ସରିଗଲେ ସରିଯିବ
13/7/2026 13/7/2026 indicating that the matter shall be disposed of, indicating in the cause list that the matter shall be disposed of. Copy of this order shall be communicated to the Learned Counsel appearing for the opposite party. सीता पर कहे कि instruction नहीं से change करते
ସେ ବାହାରେ ଅପେକ୍ଷା କରୁଛନ୍ତି ଆସୁନାହାନ୍ତି ମୁଁ ଗଲା ଥର କହିଲି
actually the clients are not listening. The lawyer is really embarrassed. Really embarrassed.
ନାଇଁ ନାଇଁ କିଛି କେସରେ ଆମେ ବି ରେସ୍ପନ୍ସିବଲ ଚାହୁଁଛୁ ଡ୍ରାଗ କରିଦେବା ପାଇଁ
ହଉଛି ଆମେ at times it's difficult to prevail. You have to exert yourself. Yes.
26.
এটা কোন এবিকে আছে না সেন্ড করে দিও তো ওটা none appears for the appellant none opposite party one লিখিবে Mr. Thank you for additional standing counsel. None appears for the appellant petitioner. When the matter is called IA लिखिए IA 2025. Grant further opportunity this in the week commencing. This is for orders in the week commencing 27 नहीं नहीं ଆପଣ 27 ର କଣ ଯାସ ଏଇଟା ଠିକ ଅଛି ତ ଆଇ ଅଛି ଆଉ 27 27 ହେଇଛି ମିଷ୍ଟର अंशुमान कॉपी सर्व ହେଇଛି କୋଡିଏ ଯୋଉ ଆଇଏ
Yes, sir, Lordship. IA has been.
Yes. Next, 27.
27.
Same. So, Pati were appearing.
Item 27, Manoj.
Yes, 27.
Manoj, in this case,
You are Mr. Satpathy.
no, on behalf of Mr. Satpathy, I am Dipankar Acharya, Manoj.
Oh, power to night. Mr.
No, no, Manoj. I am appearing on behalf of.
Dipankar Acharya on behalf of Subra Satpathy for the appellant.
Yes.
Copy serve ହେଇଛି
Manoj, may I kindly see the last order, Manoj. 21/5/2020.
Copy serve ହେଇଛି ଉତ୍ତର କେମିତି ହେବ last order?
Manoj.
अरे कॉपी सर्व ହେଇଛି କି ନାହିଁ ଇଟ୍ସ ଏ क्वेश्चन ऑफ फैक्ट लास्ट ऑर्डर कौन
Yes,
ଆପଣ କନଫିଡେंଟ ନାହାନ୍ତି ସେଟା କହିବେ ନା ମୁଁ କନଫିଡେंଟ ନୁହଁ
no, no, Manoj. Why I say so is, why the last order your lordships have had asked us to implead two parties in the appeal application, Manoj. That application we have filed, Manoj. That has not come on record. That is true. Copy served, copy served, Manoj. Copy has been served.
bang my head on the ये
No, no, Manoj. Copy served.
the office note put up by the registry indicates that copy of the receipt showing service of copies of the appeal memo on the lauded DSJ and ASC not received. Receipt कौन कले?
We'll file, Manoj. Probably it has been filed. That instruction I don't know, but I was instructed that appeal memo has been served.
Instruction no sir.
Receipt
दरकार memo.
Manoj, मैं call it.
आपको instruction important no. Registry memo दरकार memo टा file करचंती की?
That instruction I don't have whether the memo.
Who will have that instruction?
I was instructed in the morning.
Obviously, I will not have and he can never have.
Manoj.
Then what can be done?
Manoj, may call it next week. Even if not served, we'll file another copy and give the receipt in the registry.
IA file करी भी करी परिवे.
Manoj.
ये भी file करी ना.
IA filed, Manoj. 229, Manoj. That IA is not come on record.
So and service of it has not been filed. The lauded counsel for the appellant is not sure whether the copy has been served as directed at paragraph 9 of the order dated Quiz 5/2026 stuff. He submits that he shall verify, and if the copy has not been served, he shall serve the copy of the appeal memo.
Manoj.
Within
period of 2 days, Manoj.
Within a period of 3 working days.
Yes, Manoj.
And file the receipt of the same in the registry to do the needful. पण ऑर्डर गुड़ाक पढ़ू नांती की
Manoj,
ये नुआ भी पढ़ू नांती जो younger माने पढ़ू नांती
Manoj, the last order.
सेटा नोटिंग आसी कहीं ना you have to refer
Yes,
to the order.
the last
direction by the court.
Last para.
The lauded counsel for the appellant submits that steps have already been taken. IA has been steps have already been taken to implead the state as well as the Union of India as responded in the appeal. IA कितने कहले?
229 of 2026.
229 of 2026
Manoj.
has been filed. IA survey copy.
IA copy served.
We haven't received.
No.
Copy of the IA shall be served on the lauded office of the lauded DSJ as well as the lauded ASC, if not already served. The matter shall be listed along with the IA. After service of copy, the matter shall be listed along with the IA in the week commencing.
Manoj.
27
Manoj.
now the time
No, no, 27.
27 ଆପଣ 108 କଲେଣି ପରା 27
28.
Grateful.
108 ତ ଭଲ ସେଟା ଚଢେଇବା ଇଏ ତାକୁ ରଖନ୍ତୁ 28 sir. Satyaranjan Pati for the petitioner. Yes, Mr. Pati.
Grateful.
Division has been filed by the wife.
Wife.
It is some it relates to which is finished.
You are seeking not to receive anything.
No, no, my lord.
How?
There the interim application 6,000 has been given as maintenance. when the final order has been passed, the learned court below has directed 4,000. So I filed this.
Instead, କହିବେ ନା ନାଇଁ? Otherwise, I would have dictated the order that they are being agreed by receipt of maintenance.
Sorry, my. And the delay that.
Therefore, my lord, ସେଇଟା ଆପଣଙ୍କୁ ତ ଦେଖିବାକୁ ପଡିବ. IA 232 of 2026 along with with RPFM 158 of 2026. The wife in the marriage and the minor child born from the wedlock are before this court seeking revision under section 19 of the Family Court Act of the judgment dated 17/6/2025 passed by the Learned Judge Family Court Khurda in CR.P. number 223 of 2022. Every time the interim maintenance will be less or more than final maintenance? If your argument is to be accepted, how can it be? Then what is the difference between the interim maintenance and the final maintenance?
Maintenance for the timing they have.
For the timing, but
After taking all the.
Crucial, what is prima facie? Without going into the details of the evidence, materials of records and pleadings, it is granted as interim. So every time interim order is granted, a writ petition is allowed. Actually, the converse is true. Most of the time you find that many occasions, so that is how it will be after recording of evidence and considering all the aspects, actually it can be reduced. There's possibility, and every likelihood of that getting reduced also. Yes, call me. Challenging the judgment dated short. By the said judgment, the petition filed by the wife and the child, that is criminal petition number 223 of 2022, has been allowed, granting a amount of rupees. Total kete paise dete? Seti tanga samudaya 4,000 taka. Dijon jak.
2,000. 2,000 to the wife and 2,000 to the.
Granting rupees 2,000 to the wife and rupees 2,000 to the child from the date of filing of the application, that is 17/6/2025. Is submitted by the Learned Counsel for the petitioner that the amount directed is too frugal in these costly days, and also is not in consonance with the materials on record indicating income of the opposite party, husband as father. Stop. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. Returnable date be fixed to 3/8/2026. The matter shall be listed in the week commencing 10/8/2026. But it's further directed that the petitioners shall continue to receive the amount directed by the Learned Judge Family Court in so and so case number 5, without prejudice to the rights and contentions in the present application. Yes, please.
29.
Yes, mention cut. Yes, correct. Mr. Misra, they want to file counter.
My lord, as per my instruction, they have already received the payment from the sub-collector. I have deposited the amount of certificate in certificate proceeding before.
No, you mean to say that that is not part of the pleadings?
My lord, that is not.
So You file that affidavit.
ଆଜ୍ଞା ମୁଁ affidavit ଟା ଫାଇଲ କରୁଛି ସେଇଥିପାଇଁ କହୁଛି କାଉଣ୍ଟର ଇଜ ନଟ୍ ନେସେସରି ସେମାନେ କାଉଣ୍ଟର ପାଖେ ହିଁ ଫାଇଲ କରିବାକୁ
That's your choice.
ହଁ ମୁଁ ମାନୁଛି ସେଇଟା ଯେ
ମୁଁ ବି ଏତେ ବ୍ରିଲିଆଣ୍ଟ ନୁହଁ ଯେ ବିନା ପ୍ଲିଡିଂସ୍ ରେ କରିଦେବି ସେଇଟା ବି ନୁହଁ.
ମାନେ ଅଲରେଡି ମାନେ ସେମାନେ ରିସିଭ କରିସାରିଲେଣି ଆମ
Let us be very simple and straightforward.
ଆଜ୍ଞା
Let the parties have their chance of saying whatever they want in whatever decision.
Lordship may grant some less time for that.
Less time କାହିଁକି କଣ କରିବା ଆପଣ ତ 26 ମସିହା କେସ୍ ଟା ବ୍ୟସ୍ତ କାହିଁ
ନାଇଁ ମୁଁ ପଇସା ଦେଇ ସାରିଲିଣି ଆଜ୍ଞା 25 ମସିହାରୁ ପଇସା ଦେଇକି ଏନଓସି ଟା ପାଉନି ସେଇଥିପାଇଁ.
Please check, is it that you have not mentioned in the writ petition or you have mentioned?
No, my lord, I have not mentioned that they have received the amount. See, documents ମୋ ପାଖରେ ସେତେବେଳେ ନଥିଲା. Now they have issued a letter.
That you should have filed immediately. Mr. Prakash Kumar Misra for the petitioner. Mr. Naik. Yes. Mr. Naik, additional standing counsel for the
No P1.
1 and 5. बहुत जोड़ा थे 1, 5, 6 and 7. सब कलेक्टर को कॉपी करछन फिर नाजिर को भी करछन.
ନାଜିର କୁ ଡିରେକ୍ସନ ଦିଆଯାଇଥିଲା ପଇସା ଦବା ପାଇଁ ସେ ଦେଇ ନଥିଲେ.
ତାଙ୍କ ଅଫିସ ରେ ତାଙ୍କ ନିଜ ଅଫିସ ରେ ଅଛନ୍ତି ସବ୍ କଲେକ୍ଟର ଅଫିସ ରେ କରିଛନ୍ତି.
ଦେଉରେ ଯେ ଡାଇରେକ୍ସନ ସେଇଥିଲା କି ମୁଁ କରିଛି.
1 then 6 to 7 Mr. Sasibhushan Jena along with Mr. Swai for opposite parties 2, 3 and 4.
Yes.
2, 3 and 4 stuff. The matter was mentioned by the learner on behalf of the learner counsel appearing for the opposite parties 2, 3 and 4 at the beginning of the day's proceeding, seeking further time to file counter. It is submitted by the learner counsel for the petitioner that the amount deposited by the petitioner for getting registration.
In the certificate proceeding, before the certificate office.
The amount deposited by the petitioner in the certificate proceeding before the certificate officer, sub-collector,
Khordha.
Sub-collector dash Khordha, sub-collector, Khordha has been received by the opposite party two authorities. The said fact, it is submitted that the said fact also shall be brought on record by filing appropriate affidavit. Stop. Having heard learned counsel for the petitioner, the learned additional standing counsel as well as the learned counsel appearing for the number 2, 3 and 4. The matter is urgent to be listed for admission in the week commencing. 27/2026. Counter on behalf of the opposite parties shall be filed. The petitioner shall file upon affidavit
within 3 days and serving copy.
Affidavit as stated on behalf of the petitioner shall be filed within 5 working days upon serving copy thereof on the learned counsel for the learned additional standing counsel for the state as well as the learned counsel appearing for the opposite parties 3, 4 and 5.
2, 3, 4.
Counter on behalf of the opposite parties shall be filed by 22/7/2026 upon serving copy thereof on the learned counsel for the petitioner. The matter shall be listed for admission in the week commencing 27/2026. Yes, please. Patnaik. So Lagnajit Patnaik for the petitioner. Sir, Naik, additional standing counsel for the opposite party. Yes, Mr. Naik.
Last topic is lordship has direct to obtain
instruction. Yes.
We have received instruction though the amount has wrongly deposited wrong head. We have already requested financial advisor, already requested to secretary to government revenue department for release such amount, and soon after release the amount, the matter amount shall be credited to the.
So that will, close the entire thing. How much time you are seeking?
You have already requested to Korea Chara already ଦେଇଛନ୍ତି ଯେ ତମେ release କର ବୋଲି ତାଙ୍କ petition of. Immediately we have already person to lordship direction again we have intimated to please.
Korea Chara ने आज होची के 29 ଗୋଟେ ସପ୍ତାହ ହେଇଛି.
Lordship ने
8 दिन including holidays. The Lord Counsel, for the petitioner referred to the order dated 8/5/2026, wherein the detailed, wherein after hearing the Lord Counsel for the petitioner and the Lord State Council, detailed order has been recorded. Stop. The Lord Additional Standing Council, appearing for the state, submits that the order dated so and so has been communicated to the authority. Stop. He has received instructions from the authority that steps are being taken for deposit, like on transfer account, deposit of the amount in the proper head.
They have to draw for the same required payment to the claimant, and government may be moved to issue sanction order for refund of the same for drawal from relevant head of account. Wrong heading is that. I mean,
for deposit oblique drawal of the amount in proper head of account. Stuff. He seeks for the time to do the needful, so that the matter can be resolved finally. Accordingly, for the 3 weeks.
4 weeks for
the 4 weeks time for intervention of the God, nahi, Almighty. Yeah, maybe hobone apano ka. When the DT, the Almighty comes, He will take care. May be granted. Accordingly, the matter shall be listed for orders in the week commencing 36.
Obliged.
Yes, please.
31.
The present petition by husband, the challenging the order of the family court passed in order dated.
Final order.
Final order.
Then let us not start hearing. I don't want to start hearing some matters. It doesn't appear to be Corina.
So appear told none.
Because I have to complete the pending matters.
Notice जाउची से हमर आउटे प्रोसीडिंग पेंडिंग अछि से एलएमसी सेटा से अपियर करछि
एलएमसी प्रे माइनर चाइल्ड तो
हां हां सेई स्वामी स्ने भीतर आउटे डिस्प्यूट अछि सेटा
माइनर चाइल्ड रे आपनकर कोन
माइनर चाइल्ड नाउ इज मोर देन 5 इयर्स मार ये जन्मरू 4 वर्ष पर्यंत मो पार हजबैंड पार
5 वर्ष हेले कोन हो कट ऑफ डेट
ना 5 वर्ष
हेले माने बापा बाबू पळेबो
ना सेमित ना वेलफेयर ऑफ चाइल्ड इज द बेस्ट
सबमिशन करछन
ना मोर तो से 4 वर्ष पर्यंत मो पार थिले
वेलफेयर ऑफ चाइल्ड इज नॉट ए मैटर ऑफ आर्गुमेंट एटा आपनकर मटेरियल आपन आनियो पड़िबो कोन आपन मोस्ट डिफिकल्ट सिचुएशन रे भी आपन मदर पाखरे रहइबो. You have to read that those cases.
I have read and obtained some citations also. The
welfare of child ray, if in at times our argument is that the grandparents are old and ailing, they don't have any earnings, they cannot take care of a child, they themselves being so aged, but still the court has granted the custody to the grandparents.
Yes.
So you must understand, actually this is a very I mean
judicial point of decision.
I mean the considerations are very nuanced.
Not my lord.
आपण যদি সিম্পলি কইবে ওয়েলফেয়ার অফ দ্য চাইল্ড 5 वर्ष হইগলা সে রহিব বাপা
না মোর সে রাউন্ড যাও
ওভার সিম্পলিফিকেশন
না মোর সে রাউন্ড
ইন ওয়েলফেয়ার রে রাউন্ড প্রুভ করଥିଲେ এটি তো আর্গু আউথরে করি হবনি আপিল রে
বর্তমানে মো যোটা অর্ডারটা जो পাস হইছে ওয়ান্টা বাই এস পার্টি even though I am appear before the court below but no I have not given opportunity to cross examine সেটা চ্যালেঞ্জ করছি বর্তমানে এটি আসিছি
ফাইনালি কেমতি চ্যালেঞ্জ হবে আপন जो दिन एक्सपर्टिस आपनकर क्रॉस एग्जामिनेशन वाज डिनाइड
cross examination I am appear before the court
अरे फेर कहले गोटे কথা आपण भाबुछन मु बुझी पर जदी भाबुछन बुझी परने ताले कहिबे जे मु बुझी परने सो दैट मु आई कैन थिंक बिकॉज़ आपण जोडा कहिले मु बुझिली पर आपण कहली आपण सेटा तो रिपीट करले you say that you are denied the opportunity, you have been denied the opportunity of cross examining the other side by the learned trial court. सेटा गोटे सेटा केमिति हुए how that happens?
I have objection before the court will
that say court जो दिन आपनकर गोटे पर्टिकुलर ऑर्डर रे लिखा हबो that evidence on so and so is complete on behalf of so and so is complete, cross examination is also complete. सेही ऑर्डर ता आपण चैलेंज करिवे कारण तापर सेटा फेर जीवो आपनकर आर्गुमेंट स्टेज को जीवो आपण आर्गुमेंट करछन्ती ना नै
argument will
अदर को आर्गुमेंट हेनी माने आपण
I am living at Barampur The case was proceeding in
Barampur ji rahibo taro argument
No, no, Barampur.
sir talk some law. Mr. Raut always try to
No,
develop.
the conducting counsel has not intimidated the facts or
He's the favorite what you call whipping boy. Always blame the lawyer. This court doesn't entertain such pleas.
please run on.
Conducting ଆପଣଙ୍କର ସେଇଟାକୁ instead of giving a speech here against the lawyer, you should show the order sheet. How the proceeding is unfair, challenge that. Conducting counsel କଣ କରିବେ?
Conducting counsel
ଆପଣ ଯାଇଥିଲେ ସେଠିକି ସାକ୍ଷୀ ଦେବାକୁ ସେ conducting counsel କୋର୍ଟ ଦ୍ୱାର ମୁହଁରୁ ଫେରେଇଦେଲେ।
जो स्टेप टा नबा था से नॉन नहीं इंटिमेट करेली
ସେଟା ଆପଣ କେମିତି କହୁଛନ୍ତି?
within 3 months ଭିତରେ the final order pass ହେଇଛି ତେଣୁ ଆମ ଯୋଉ
3 days is not immaterial, Mr. Raut. Blaming the lawyer is a easy job.
No, now the opportunity is I am only challenge the final order except I will no
ସେଟା ଯଦି ସୁପ୍ରିମ କୋର୍ଟରେ କଣ ଥିବ ଆଣିବେ ନା ଯେ ଆପଣଙ୍କର ଯେତେବେଳେ ପ୍ରୋସିଡିଂ ହେଲା ଆପଣ ଏକ୍ସପର୍ଟି ହେଲେ ଆର୍ଗୁମେଣ୍ଟ କଲେନି
ଆଉ ଗୋଟେ ବେଟର ହବ ଯଦି
ଆପଣ ଶୁଣିଲେ ସବୁଠୁ ବେଟର ହବ ଆପଣ ଶୁଣିଲେ ବୁଝିପାରିବେ
ନା ମୋର
କହିଲେ ବୁଝି ହବନି
ମୋର ଦିଟା
ଡିଫିକଲ୍ଟି କଣ ହଉଛି କହିଲେ ମୁଁ ଯାହା ଆପଣଙ୍କୁ କହୁଛି ଆପଣଙ୍କ ଭଲ ପାଇଁ ଆପଣ କିଛି ଶୁଣୁନାହାନ୍ତି ଯାହା ଆପଣଙ୍କୁ କ୍ଲାଏଣ୍ଟ ଆସି କହିଛି ସେଟା ଆସି ଗପୁଛନ୍ତି ଦ୍ୟାଟ୍ ଇଜ ଏ ଭେରି ବ୍ୟାଡ୍ ହ୍ୟାବିଟ୍ ଫର ଏ ଲୟର ଆପଣ ଯୋଉଦିନ ଏକ୍ସପର୍ଟ ହେଲେ ସେ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରିଥାନ୍ତେ ଯୋଉଦିନ ଆର୍ଗୁମେଣ୍ଟ ହେଲା ଚ୍ୟାଲେଞ୍ଜ କରିଥାନ୍ତେ ବର୍ତ୍ତମାନ ଆପଣ ୟୁ ହାଭ୍ ବିକମ୍ ୱାଇଜର ଇନ୍ ହାଇଣ୍ଡସାଇଟ୍ ଯଦି ସେମିତି କିଛି ଥିବ ସୁପ୍ରିମକୋର୍ଟ ଡିସିଜନ ଯେ ନାଇଁ ଆପଣ ଯେବେ ଚାହିଁବେ ଚ୍ୟାଲେଞ୍ଜ କରିବେ ତାହେଲେ ଦେଖିବେ ଷ୍ଟ୍ରେଟ୍ ଆୱେ ବିକଜ ୟୁ ଆର୍ ଫାଇଟିଂ ଫର ସମବଡିଜ୍ ରାଇଟ୍ ସୋ ୟୁ ହାଭ୍ ଟୁ ଟେଲ୍ ମି ଦ୍ୟାଟ୍ ଏନି ଟାଇମ୍ ୟୁ ଲାଇକ୍ ୟୁ ୱିଲ୍ ଚ୍ୟାଲେଞ୍ଜ ଦ୍ୟାଟ୍ସ ଇଟ୍ ଗୋଟେ ଜଜମେଣ୍ଟ ହେଲେ ସରିଲା ଆପଣ କିଏ ଚିଠି ଗଲେ ଆପଣ ରିମାଣ୍ଡ ହେଇକି ଯିବ ବଟ୍ ଏଠି ଆପଣଙ୍କର ସିଷ୍ଟମ ନାହିଁ ଯେ ରିମାଇଣ୍ଡର ଦେବେ ଇଏ କରିବେ ଥରେ ଆପଣ ଆସିବେ ଆପଣ ଯଦି କହିବେ ଯେ ମୁଁ ଆଜ୍ଞା ଯାଇଥିଲି କୋର୍ଟରେ ମତେ ଲୟର ମନା କଲେ ଏଠିକି ଆସନି ପଳା ପସିବଲ ମୁଁ କହୁଛି ଆପଣ ଗୋଟେ ଉଦାହରଣ ଦଉଛି ସେଟା କଣ ହୁଏ
ଆଉ ଗୋଟେ ସମିଶନ ମୋର ହଉଛି ପିଟିସ ଆপিଲାଣ୍ଟ ଆଣ୍ଡ ରେସ୍ପଣ୍ଡ ମଧ୍ୟରେ ଆଉ ଦିଟା ପ୍ରୋସିଡିଂ ହାଇକୋର୍ଟରେ ପେଣ୍ଡିଂ ଅଛି ଗୋଟେ ହଉଛି ଆରପିଏଫଏମ ଅଛି ଗୋଟେ ଆଉ ଗୋଟେ ହଉଛି ସିଏଲଏମସି ଅଛି ମୋ ମତରେ ସିଏଲଏମସି ରେ ୱାଇଫ ଅଛି ଆପିଏଲ and mediation is continuing ଯଦି ତିନିଟା କେସ୍ ମିଶି ଯାଆନ୍ତା ତାହେଲେ ଗୋଟେ ଆଡଜୁଡିକେସନ
ମାନେ ଏଟା କଣ ପାଣିରେ ଗ୍ଲାସରେ ଢାଳି ମିଶେଇବେ ଫେଣ୍ଟିବେ
ନା ନା
ଲ୍ୟାକ୍ ଅଫ ଡିଟରମିନେସନ ହବ ମୋର ସିଏଲଏମସି ଜୁରିସଡିକ୍ସନ ଅଛି
ନାହିଁ କିନ୍ତୁ ମ୍ୟାଟର୍ନାଲ ଡିସ୍ପ୍ୟୁଟ ଆରପିଏଫଏମ ଟା
this is not liquid to be poured over a glass that is another liquid
ନା ସିଆରଏମସି ଟା
mixes well with water
ନା ସିଆରଏmsi ଟା arising out of maintenance
talk sense you are being watched and we are recorded what you are saying that CRLMC GUAP guardianship appeal ଆଉ ଗୋଟେ କଣ ବେଲ୍ ନା କଣ
ନା ନା ଗୋଟେ ଆରପିଏଫଏମ
ବସ୍ ଆରପିଏଫଏମ ସବୁ ମିଶେଇକି କରାଯାଉ ସେଟା ନାହିଁ
ନା ବୋଥ ପାର୍ଟି ସେମ୍
ଆରପିଏଫଏମ ରେ ବୋଥ ପାର୍ଟି ସେମ୍ ହେଲେ ମିଶାଏ ସେମିତି କିଛି ପ୍ରୋଭିଜନ ନାହିଁ ଶୁଣନ୍ତୁ ଆଜ୍ଞା ଆପଣ କଣ ଏଠି ଆର୍ ୟୁ କମିଂ ୱିଥ୍ ଏ ରିକ୍ୱେଷ୍ଟ ୟୁ ଆର୍ ଫାଇଟିଂ ଆର୍ଗ୍ୟୁ ୱିଥ୍ ଅଥରିଟି କହିବେ ସେଇଟା ସିଧା କହିବେ ଆଜ୍ଞା ଜିୟୁଏପି ରେ ଜିୟୁଏପି ଆଉ ଆପଣ ମିଶେଇ ଦେବେ ସିଷ୍ଟମ ଗୋଟେ ଅଛି ପ୍ରୋଭିଜନ ଅଛି
due to matrimonial dispute between husband and wife I am asking the dog
ମୁଁ କଣ କହିଲି ଯେ matrimonial cordiality ପାଇଁ ହେଲା did I say that due to matrimonial cordiality they are fighting it out but talk some semblance of respectability in our discussion you are a lawyer I am being educated by you I should be ଆପଣ ମତେ କହିଲେନି ଯେ ମତେ ତ ଭଲ ଲାଗୁଛି ମୁଁ ଜାଣ ମିଶା ତାକୁ ସବୁ ନେଇ ଆସ ଏଠି one single point adjudication ସେମିତି ହୁଏନି ଆଜ୍ଞା ଭାବନ୍ତୁ କଣ କରିବେ ମୁଁ ଭାବିଲି ଆପଣ ଆଉ ଗୋଟେ କଥା କହିବେ ସେଟା ମୁଁ ଆଇ ୱାଜ ଏକ୍ସପେକ୍ଟିଂ ଦ୍ୟାଟ୍ ବଟ୍ ଆପଣ ସେଟା ବି କହିଲେନି
due to
ସାର୍ ୟୁଜୁଆଲି ଏ କେସରେ ଆପଣଙ୍କର ଆଉ ଗୋଟେ ପ୍ରେୟାର କରାଯାଏ ଠିକ ଅଛି ଛାଡ଼ନ୍ତୁ the matter is listed for admission for hearing under the heading for admission non appears for the petitioner Mr. Brunda ଆପଣ ଏମିତି ଅବାନ୍ତର କଥା କହିଲେ ଯେ I have felt your absence actually Mr. Vrindavan Rao for the petition appearance lecture opposite party none the none appears for the opposite party when the matter is called to grant further opportunity the matter shall be listed for admission in the week commencing चिठी गले 32 नो आयो डेट को
27
27 7 20 26 ତା ଭିତରେ ଭାବନ୍ତୁ କ'ଣ ବେଷ୍ଟ କରିହବ। I will almost dictate a mohil upon said I କହିବେ ମୁଁ ସେଟାକୁ I will about to dictate that ଆପଣ ଆଉ ଗୋଟେ କ'ଣ କହିବେ? Yes.
Item 32.
32 ଆପଣଙ୍କର ଯୋଉ notes of submission I am not here today. I will try to catch up with some pending one. I am not opening briefs for staff. Date ଗୋଟେ କରନ୍ତୁ 32 ଟା।
Income 3 years.
May they put it sorted because each month the petitioner is paying.
He has to pay, sir. That is not a consideration for granting short adjournment.
It is two primary issues.
Jyoti says that Javi primary issues, just like we are discussing with Mr. Raut, you have to cite some law. ଗୋଟେ ଓଜନଦାର କରନ୍ତୁ ଜିନିଷଟାକୁ ଭଲ ଲାଗିବ ସେଇଟା ମତେ ବି ଭଲ ଲାଗିବ ଆଉ ସେଟା ତାକୁ ବି ଭଲ ଲାଗିବ ମିଷ୍ଟର ମିଶ୍ର ତାର ରିପ୍ଲାଏ ଦେବେ you come out with a proposition so that he will reply ଆପଣ ଯଦି କହିବେ ସେ ସବୁ ମାସରେ ଦଉଛି ଜଲ୍ଦି କରନ୍ତୁ ସେ ସେଠୁ କହିବେ ଯେ ସବୁ ମାସରେ ଦଉଛନ୍ତି କ'ଣ ହେଇଗଲା ସେଇଠୁ ମୁଁ କହିବା ସବୁ ମାସ ଦବା କଥା କାରଣ ସେକ୍ସନ 24 ସେକ୍ସନ 125 144 ସବୁ ଅଛି ଆହୁରି ବି ଅଛି there are so many sections so that is not yes in address ତାଙ୍କର କହିବାର actually ଆଉ ଗୋଟେ reason ଅଛି ସେ ତା ପୂର୍ବରୁ actually around 450 matters already ଅଛି
only one ground challenge they have not recorded the satisfaction while giving the ex parte order.
Let us see.
Please.
Yes, next.
33.
3 8 27 ହବ ନା କଣ ସେ ଗୋଟେ week difference ହବ ତା ପୂର୍ବ ପର୍ଯ୍ୟନ୍ତ around in fact there are 400 ठीक ଅଛି 27 ରହୁ ମିଷ୍ଟର ମିଶ୍ର 27 କହୁଛନ୍ତି ठीक है yes
lordship my lord it is decided only the quantum of the maintenance lordships here the trial court the judge family court has passed order to pay 15,000 that means more than about 50% of the income my lord here my pit
40% habo
my 25% 25% ଅଛି judgment
25%
yes
Odisha High Court 40% 40 I will follow 40% ଆପଣ ଯେମିତି 25% ଫଲୋ କରୁଛନ୍ତି ମୁଁ ସେମିତି ସୁପ୍ରିମ କୋର୍ଟ ଆଉ ଓଡିଶା ହାଇକୋର୍ଟ ର ଅଛି 40% ତାକୁ ଫଲୋ କରିବି
no supreme court
40% ନାହିଁ
କଲ୍ୟାଣ ଦେ ଚୌଧୁରୀ and ରୀତା ଦେ ଚୌଧୁରୀ my lord
କଲ୍ୟାଣ ଦେ ରୀତା ଦେ ହଉଛି ଆଜ୍ଞା ପର୍ମାନେଣ୍ଟ ଆଲିମନି ଆରପି ଫାର୍ମ ନୁହଁ ସେଟା କଲ୍ୟାଣ ଦେ ରୀତା ଦେ ପଢନ୍ତୁ ପୁରାଟା ପଢିବ ସବୁବେଳେ so that ଆପଣଙ୍କର ନ କଲେ ଆପଣ weakest point ହେଇଯିବ when you cite a decision completely against you that becomes a boomerang and for weakest point kind of say you rely kari
no here only
now listen
yes
Kalyan Dev rely kari I can very well direct 40% because that is not applicable distinguishable I mean not applicable kahata thik no it is clearly distinguishable about 40% re hela take instruction mu nahi I am not asking se aji ebe commit karantu boli a jodi 35 enti hei paribo tale Mr. Sahoo will be happy resolve ହେଇଯିବ
only source of income is pension lordships that is only pension my lord
only pension ଦେଖନ୍ତୁ very good judgment written by Justice Deepak Mishra and Samima Faruqi the pensioner ହେଇଗଲା ବୋଲି ତାକୁ କମେଇ ଦେଲେ High Court କମେଇ ଦେଲେ Honorable Justice Mishra has said that non application of mind by High Court ଆପଣ ମାନେ ସେଇଟା କରିବାକୁ କହୁଛନ୍ତି
25%
pension ରେ ଆଜ୍ଞା 40% ପାଇବେ ସେ କ'ଣ divorced
no divorce
but unfortunately most of them but God forbid
they are residing in last 22 years husband wife thereafter deserted now residing separately
that's more the reason ବଢିବା ପାଇଁ ଆପଣ ଯଦି apply କରିବେ 22 years relation ମାନେ matrimonial life that's a clear indicator for more in as far as what is Rajneesh versus
no she very
more the
very sorry to say my lord she is adulterating she is even adulterating but unfortunately
adultery is not a matter of speech
my lord that is difficult
so she is in the impressive speech ଦେବେ ତ ସେଥିରେ କ'ଣ ଅଛି କି ମୋର କାମ ହେଲା very simple ଯେ prove କରିବେ the court looks for evidence recently somebody I read it very succinctly said by somebody that the court looks for evidence any order Mr. Thor so Sahoo I remember this Ms. Bhagat so you take instruction on that ହେଲା ଦେଖ ଯଦି 20% ଆପଣ ରାଜି କରି ପାରିବେ ତ it will nothing like it ଆଉ ଠିକ ଅଛି ନାଇଁ ଆରେ that is in a lighter vein That is after I have said that you do it. Okay. Kebe asibo? Kebe asile habo? Apon kebe kotha hi paribe? 3 সপ্তাহ ঠিক আছে
My lord, there is twist. IA is there, my lord. IA 516 of 25, not press lordships. 2 IA is there.
তাহলে 32 লেখন্তু মিস্টার হরপ্রসাদ পণ্ডা for the petitioner, Mr. Tushar Kumar Mishra for the opposite party. What you mark? When I started dictating, when Mr. Sahoo said not pressed, I had no option but I have to pass a order. I was purposefully not passing any order to reduce the work of because adjournment computer reset I so obviously 32 was left with in their though they were present, no order was passed. So they have to be respected or not? Or only Mrs. Bhagat and Mr. Sahoo, their case is taken up, order is passed. Prasad Panda, Mr. Tushar Kumar Mishra for the opposite party. The matter is listed for hearing under the heading for admission. Shall be taken. It is adjourned to be listed for admission on 27. You know, we commencing 27 Korea. 26. Mr. Chittaranjan Sahu for the petitioner.
Excused, Your Lordship. Till then, let him pay something, he's not paying anything.
Don't worry.
Lower court minors, they have
ମୋର କହିବା କଥା ଯେ ଆପଣ ଯଦି ଗୋଟେ achieve କରିବେ ultimately ଭଲ ଜିନିଷଟା little bit patient. ଆପଣ impatient ହୁଅନ୍ତୁ ନାହିଁ. I mean ଆପଣ ମାନେ I mean not your client. She will be always impatient. If there is a way out to achieve a solution, you have to absorb that shock. ଆପଣ ଯଦି ସେ ଆସି ସବୁଦିନ ବ୍ୟସ୍ତ କରୁଛନ୍ତି ଆପଣ ହିଁ ତାଙ୍କୁ ବୁଝେଇ ପାରିବେ. In that way I am telling you.
No, during pendency, the judge family court is passed an order to pay 5 lakhs, my lord. Order is there, lord, with me, my lord.
ଆପଣ ଆଙ୍ଗୁଠି ଦେଖୁଛନ୍ତି.
Okay? No, sir.
The Lord Judge Family Court, she ତ ଏଠି ଅଛନ୍ତି. She is not the Lord Judge Family Court.
ଅଛି order ଟାକୁ sir ରଖିଛି ଏଠି।
ସିଆଡେ ଦେଖିଲେ ଏଇ ସବୁ ଜିନିଷ that leads to skirmishes.
No, that's why I am telling my lord.
Anyway, I am not passing any order. ମୁଁ ତ ତାଙ୍କୁ ମନା କଲି ଆଜ୍ଞା। ଫେର ଆପଣ The Lord counsel for the petitioner as well as the Lord counsel for the opposite party were had at some length. The Lord counsel for the opposite party shall obtain instruction in terms of the discussions held today. Held by instruction in terms of the deliberations made today. ଆପଣ କହୁଛନ୍ତି 50% ସେ ଦେଇଛନ୍ତି ନାଇଁ?
ଆଜ୍ଞା।
You said 50% ଦେଇଛନ୍ତି।
ଆଜ୍ଞା ଆଜ୍ଞା।
So ସେଇଟା ଆପଣ ଟିକେ ଦେଖନ୍ତୁ। Around 40% ଦେଇପାରିବ ତାହେଲେ we'll go ahead. IA 516 of 2025 Chita is not pressed.
Okay.
The IA has been filed by the petitioner. The learned counsel for the petitioner files memo de diyo sir.
Okay.
Stating that the petitioner does not wish to proceed with the IA, accordingly the IA is disposed of. बाकी जो IA 4-5 ଅଛି ସେ କଣ?
ଗୋଟେ IA sir ଅଛି further proceeding of execution case. That may be
ଅଛି ଗୋଟେ
further proceeding again. IA 102 of 226. That is further proceeding stay of execution case.
61 ଟା
61 is the ତଳ court ର।
IA 102 of 2026
ଆଜ୍ଞା ସେଇଟା sir ମୁଁ ଚାହୁଁଛି I want to stay of further proceeding.
ସେଟା adjourn ହବ। IA 102 of 2026 the IA has been filed. The prayer for stay of further proceeding in criminal execution case number 148/2025 pending before the Lord Judge Family Court Bhubaneswar. Stop. The entry but is directed that upon a prayer being made upon a prayer being made the The said the execute the said execution the said CRL dot execution case number 148 of 2025 shall be adjourned to a date beyond. এটা আপনি কেবল রাখছেন তিন সপ্তাহ করছেন আজকে কোড়িয়ে date beyond 27/7/2026 the matter shall be listed for admission in the week commencing 27/7/2026. Yes. Other IA?
No, but only two I is there.
Okay. In the 148 কোটে আছে আচ্ছা স্টেট সেন্ট্রাল গভর্নমেন্ট কাউন্সিল কি অଛନ୍ତି কি নাম the registry shall intimate the learned office of the TSDI regarding the order dated 34/2026 and seek instruction. Yes.
Thirty-four.
34 another date. Yes. Then 36 Mr. Bishwa. डेट कॉलेज नहीं मिस्टर अपना स्कूल ना
We council तीन है.
yes
36.
I have filed a rejoinder to the counter affidavit filed by opposite party note 2, my lord.
रिजेंडर का रिकॉर्ड है नहीं
नहीं मु आज ही फाइल कर रिकॉर्ड फाइल कर देबे रजिस्ट्री अच्छी मो पाकर रजिस्ट्री कर दे.
You are associate of Mr. Sharma.
Yes.
Mr. Anjan Kumar Vishwal for the petitioner. Mr. Naik, additional standing counsel for OP1. You are Mr. Sahoo. Mr. R. Sahoo for the opposite party along with the number opposite party. OP2.
Is for OP2.
OP2, OP1 is OP2. Along with Mr. Bigyan Kumar Sharma, senior advocate, along with Mr. Rudra C. Sahoo for OP2. It is submitted by the learned counsel for the petitioner that rejoinder to the counter of the opposite party number 2.
2 only.
Is filed by the petitioner today in the registry.
अच्छी मो पाकर यदि नेबे इटे देबे ना
It is actually misplaced over.
आज्ञा मु ताम कॉपी सर्व कर देछि.
Registry copy of the rejoinder is served on the learned counsel for the OP2 as well as the learned additional standing counsel. The rejoinder shall be taken on record, scanned copy be updated. The matter shall be listed for admission in the week commencing 10/8/20.
मोर बंद सरी जीवो पीरियड टा सर जीवो पीजी रो लास्ट हला अगस्त हमर
ताले 27/7 रखते हैं.
आज्ञा आज्ञा था देखिबा एंट्री मॉडल में भी एक्सटेंडेड
एंट्री मॉडल
24/4/2025
डेटेड केते
24/4/2025 आपण
24/4/2025 shall continue till the next date of hearing.
37.
Yes. But today I have no time to hear matter, so I will not open the. So you take a date.
Yes, minutes.
37, Mr. Anup Kumar Mahapatra for the petitioner, Mr. Panchanan Panigrahi for the opposite party. The matter is listed for hearing under the heading for admission. It is adjourned to be listed for admission in the week commencing 37/7. So Panigrahi, 37.
Yes.
What about our matter upon non-appearance? Kindly mention the serial number.
21, madam.
21. 21 लेखो तो मेमो दियो कागज दियो 21 होची 500 वर तुझे नहीं थिबे तो ऑर्डर काटी आउथर लिखियो पड़िबे किने ने नंबर साथ लेछो कहि देबे तो पंचानन पाणीग्राही फॉर द पिटिशनर मिस्टर opposite party black ରହିବ The matter was presented before, matter was presented before this court on 11/11/2022. The petition has been filed by the husband in the marriage challenging the judgment dated 25/9/2021 passed by the Lord Judge Family Court Nabarangpur in CR.P. number 31 of 2021. By the said judgment, the petition filed by the wife in the marriage as well as the minor child born from the wedlock was allowed by the learned court, directing payment of monthly maintenance of at the rate of rupees 3,000 for the wife and rupees 2,000 for the child from the date of the application. From the date the application was made, that is 21/2021. The matter being listed for orders, memo of date is filed by the Lord Counsel for the petitioner. It states thus. The memo shall be taken on record, scanned copy be updated. In view of the above, the petition stands, in view of the memo, the petition stands disposed of. Copy of this order shall be forwarded to the Lord so and so, so and so. To be kept in the records of so and so, so and so. Disposed of so and so. Yes. Password.